in the cloud. So I start. Welcome to everybody. This is the 4th annual conference of the Academy of Law and Migration. As you may know, the Academy is a scientific network established in 2018 at the University of Tuscia. It involves more than 400 scholars, mostly from Italy, but increasingly from other European and non-European universities. Today's conference asks the following question: what role for EU agencies in migration and asylum governance? Last year, we devoted the annual conference of the Academy to the new pact on asylum and migration. Now, this year, while waiting for the deadlock on the pact to be unlocked in Brussels, our conference will take us to another level. We will move from the legislative dimension of the pact to the implementing or administrative dimension. And in fact, today's conference aims to highlighting and discussing the issues related to the implementation of EU law in the realm of migration and asylum. In organizing this conference, we made two general assumptions, which of course can be challenged during our discussion. The first one is that although less attractive and often overlooked, implementation problems are actually crucial to understanding and assessing the consistency of both the current EU legislation and of the new legal framework proposed in the pact. The second assumption we made is that EU agencies play an increasingly relevant role in the implementation of EU law, especially in the area of justice and home affairs, where we have agencies such as Frontex, Europol, and EASO, whose mandates are increasingly expanding with consistent additional resources. And this expansion of operational and implementing capacities raise several issues. We want to deal with this conference mainly with two of them. The first is functional, is more functionally oriented, and it is whether and to what extent the expanding mandates of these agencies offer adequate responses and solutions to the implementing needs and gaps of the European governments in the migration field. And the second question is more normative in character, and it is whether and to what extent the current accountability mechanisms, including human rights monitoring, are sufficient to cope with the operational and administrative tasks entrusted with those agencies. Now, in the first session devoted to experimentalist governance versus integrated administration, we have two speakers. One is JACOPO ALBERTI, Associate Professor of EU Law at the University of Ferrara. He is author, inter alia, of an important book on EU agencies published in Italian in 2018. The other is VALSAMIS MITSILEGAS, Professor of European Criminal Law and Global Security, and also Director of the Criminal Justice Center and Deputy Dean for Global Engagement at Queen Mary University of London. As you all know, he's also the author of several books and articles in fields of several fields ranging from European criminal law to migration and asylum, security and human rights, and so forth. Now, before leaving the floor to Jacopo, allow me to express my most sincere gratitude, first of all, to the 6 distinguished speakers for having accepted our invitation, as well as to the other colleagues and scholars for being here connected to this event. Since the Academy is a free and open network, allow me also to invite you all to join it. It is sufficient to have an academic affiliation, being a PhD student or a postdoc or a faculty member, to join this network. And the process for joining is very simple. I kindly ask Giulia Del Turco to post the link in the chat. Let me also acknowledge that this conference has been organized in cooperation with and with the support of the Jean Monnet Center of Excellence on the Integration of Migrants in Europe, whose acronym is INTO-ME. This center has been established at Touche University in 2020 as a spin-off and crucial asset of the Academy. Now, both the Academy and the Center of Excellence rely on the extraordinary energies and the intellectual resources of a great team of young scholars and colleagues who are behind this event. Let me mention Alessandro Bufalini and Daniela Vitiello, my dear colleagues with whom I share the coordination of the Academy, Francesco Gatta, who worked very hard in order to finalize this event, along with Giulia Del Turco and Maria Teresa Veltri, who also deserve a special mention. Many thanks to all of them, and to all of you, actually. Finally, let me remind the few rules of the game. First of all, the works of this conference are registered. Those who participate implicitly give their consent to the registration. Second, please keep your microphone off, except when the chair gives you the floor. Third, let me remind you that this panel will close at 3:35 and will be followed by a second panel starting at 3:45 p.m. In order to respect this timing and allow some time for the discussion, I will kindly ask all the speakers to present their views in 15 minutes. Now it's time to turn to the substance of the conference. We will start with JACOPO, who will offer a general overview of the problems related to the design and accountability of EU agencies in general. His presentation deals with decentralized implementation through agencies, features, problems, and perspectives. Jacopo, you will open the dances. The floor is yours.
Thank you so much. It's really a great pleasure for me being here. I always dealt with EU agencies in general without focusing on specific policy fields. So I'm very much looking forward to the discussion to learn from such a qualified audience what I can learn looking through the prism of the area freedom, security and justice agencies. That's the title, Professor Savino, and thank you first of all to the organizing committee and to our chairman for inviting me. It's really a pleasure, as I mentioned. Professor Savino has already recalled the title of my presentation that could also be subsumed under what can be learned from other EU agencies. What AFSJ agencies can learn from the experience of other agencies. And for this reason, I would like to sketch very briefly and give you a broad overview of the problems and perspective concerning the decentralized implementation by EU agencies. Of course, I'm open to discuss the specific things that I will mention very briefly during the discussion. Let me first of all put a huge caveat before my presentation, which is EU agencies functions and have performed quite well so far. The first agency has been established in 1975, so it's almost 50 years of EU agencies within the EU legal order. Also thanks to their heterogeneity. EU agencies are different one from the other, and this means that what works within an agency does not necessarily work within another agency. And of course, I think we have always to respect the specificity of each policy field and of each agency. Therefore, the idea behind this presentation, and I hope to have get the right approach from our from the organizing committee, is to give you an overview, but of course that should give some food for thought, if you allow me to use this metaphor, to discuss the specific problems of the AFSJ agencies and first of all of Frontex and EASO. But of course, nothing can be exactly replicated from a policy field to another. I won't bother you concerning the different type of function that EU agencies perform, because I think that this topic has already been debated quite extensively in legal doctrine. We can come back to to this if you want afterwards. I would like to directly deep on the issues that have arisen so far in the decentralized implementation made by agencies. And for doing so, I have to start with the original scene of European Union agencies. Because perhaps scholars coming from the area of freedom, security, and justice have a different perspective on these, in the sense that if you think about Europol and Eurojust, well, those agencies are the only one, together with the European defense agencies, that are explicitly mentioned in the treaties. All the other agencies do not have any specific legal basis in the treaties. So the original scene of agencies is that, okay, the very first one had been established in 75, okay, but then during the 90s, most of agencies have been established, so from the 90s onwards. And here comes the paradox. So on the one hand, the European Union and the member states did want to establish agencies because they need to cooperate more deeply at supranational level. However, they did not want to further magnify the profile of the European Commission, because of political reasons, basically. We can discuss this point afterwards, but to make a long story short, that's the point. The paradox is that, on the one hand, new bodies have been created, to some extent to cooperate with the other existing institutions, like the Commission or the Council. But on the other hand, such a political willingness has never been transposed and has never been codified in the existing treaties. If you take the Treaty on the European Union and the functioning of the European Union currently in force, then you will notice that we still not have, after 47 years of agencyfication and 37 agencies established in different policy fields of the Union, after that, we still do not have any legal basis to establish an agency. We still do not have a legal basis that tell us which act can be adopted by an agency. We still do not have a legal basis, and that's particularly important in the field of decentralized implementation. We still not have a legal basis telling us which role can be played by EU agencies in implementing EU law. If you take Article 290 and 291, that's the place for looking for implementation of EU law. Well, EU agencies are not mentioned over there. Just the Commission, Article 290, Article 291, Paragraph 1, the Member States, and Paragraph 2, the Commission or the Council together with the Member States. So there is still no room for EU agencies within the EU treaties, so a very scant legal recognition and legitimation within the treaties. Where agencies are explicitly mentioned, just within judicial protection. If you take the prerogatives of the Court of Justice, then you will notice that EU agencies are mentioned therein. Does it mean that EU agencies do not pose any problem in the field of judicial protection? Unfortunately not, and I will come back to this in a second. But that's the original scene, let's say, behind, and I think that we have to have it in mind pretty importantly, because that, of course, affects the way in which EU agencies implement EU law. On the one hand, we have powerful agencies, more and more powerful all over the years, but they still do not have any legitimation within the EU treaty. So now, which are the issues that arise from this situation? I think that they can be divided into three categories: institutional issues, normative issues, and the so-called accountability issues. Institutional issues, very briefly. Of course, these, let's say, this scant recognition of EU agencies and the fact that EU agencies have been established to some extent to perform functions that originally speaking were thought to be performed mainly by the European Commission or by the same member states, has created, as we all know, a quite huge overlap in terms of functions between EU agencies and other European Union institutions, or EU agencies and the member states. Because EU agencies, to some extent, have circumvented also the principle of conferral, performing functions and bearing the competencies that, theoretically speaking, should be made by the same national administration. We all have in mind the role played by Frontex and the ASO in the field of border control and asylum request. However, people working in the financial and banking fields will think about the role of the teams of the Single Resolution Board in checking the failure of credit institution, or the role performed by the civil servant of the European Central Bank in supervising national banks together with the national civil servants. The ECB, the central bank, is not an agency as such, but it's a quite powerful independent authority, and I think that we have to keep it also in mind. There is an overlap in functions also also with regard the prerogatives of the European Commission, so of the other institution of the European Union. Very briefly, just think about the power of controlling the implementation of EU law by the member states. Article 32 of the Frontex regulation, or Article 22 of the new European Union Asylum Agency regulation, if and when it will enter into force. I'm referring to the very last proposal, which is under discussion. Well, these two legal bases give a possibility to Frontex and EASO to some extent to support the Council and the Commission in controlling that member states properly implement EU law. It's the field of the vulnerability control of Frontex, in the case of the disproportionate pressure of the common asylum system in the field of health. Well, these examples are not alone, because many other agencies perform quite similar function in the field, in this field, and I'm referring to the role of the European Aviation Safety Authority, or the European Railway Authority, or the European Agency for Cooperation of Energy Regulation, that have the possibility to perform inspections. And the same applies to the very brand new European Labour Authority, which has already been established, but its mandate it's not operational yet. But all these agencies have the possibility to conduct inspections on the field in the member states, so as to give information to the European Commission to eventually start an infringement proceedings. And even more intrusive powers are those of the three European supervisory authorities in the field of financial and banking regulation, which has the power to sanction a member state that does not properly implement EU law, also circumventing the prerogatives of the European Commission in the field of the infringement proceedings. And perhaps these examples can be useful also to imagine a new scenarios for Frontex and EASO. We can come back to this more in detail in the discussion if you are interested. Another point of overlapping very briefly, of course, is the one of the external dimension. Daniela Vitello has wrote extensively on these. AFSJ agencies, so mainly Europol, Eurojust, and Frontex, are those that adopt quite a lot of international arrangement, memoranda of understanding, or whatsoever. They are not alone, absolutely not, because all the other agencies, even those dealing with intellectual property rights, adopt soft acts, so soft kind of international arrangements on the international level. Here, the problem that arises, in my view, with regards to Frontex, but also all the other agencies, are the necessity to fully respect the prerogative of the Council on the international level, because according to Article 218 TFU, it's up to the Council to check the international dimension of the European Union and not only of the Commission. But also the prerogatives of the Court of Justice, because again, according to Article 218, paragraph 10, the Court of Justice has got the power to check whether international agreements by the EU are compatible with the treaties. And the role performed by EU agencies in this regard is absolutely, has to be checked, and unfortunately the external dimension of agencies is absolutely underexplored. But I think that in this point, Frontex could teach something to the other agencies. Indeed, Frontex, according to my knowledge, is the only agency whose establishing regulation foresees that the European Parliament should always be kept informed of the international, let's call them arrangements, are signed by Frontex. I think that this is something that should be exported from Frontex to all the other agencies, because it does not happen beyond Frontex. Let's go deeply to the normative issues, even quite briefly. The centralized implementation made by agencies highly relies on soft law. EU agencies uses a lot of soft law to perform their function. Why? because of the original sin we mentioned above. So technically speaking, EU agencies has no implementing power, so has no power to implement EU law according to Article 90.1. How can I do that? Through soft law. Because technically speaking, if I implement EU law through soft acts, I am not circumventing the prerogatives of the member states and of the European Union. This use of soft law has many negative implications on judicial protection. I will come back to this in a second. On accountability, because of course soft law is much less transparent and open for participation by other entities. So it has always been perceived as something negative. I think that what is important here to highlight and I think that here legal scholars should bring their analysis a step further, in the sense that soft law is usually being checked from a normative perspective, which are these acts, why they are adopted, and so on and so forth. I think that what is crucial here is to develop a more operational approach, checking on the field and to measuring on the field the concrete impact of soft law over the regulated entities, so over individuals and member states. Because of course, the more binding soft law will be for the member state and for the individuals and the legal person, the bigger will be the problems created by soft law, and of course vice versa. In this view, I think that EASO is an extremely interesting example to be studied. Soft law has also got, it does not simply have shortcomings, but it also has some positive side issues. We'll come back to these during the discussion, because I think it's something quite important to be highlighted, in the sense that, according to the research I made so far, to some extent, soft law it's also needed by national administration and by national judges, which are to some extent happy to receive a guidance from a supranational authority, very expert in that specific field, telling them what should be done, how a specific situation should be interpreted. However, leaving national judges and national administration free to interpret how they prefer national legislation, since technically speaking, soft law is not binding. And I think that here there is a kind of theater between the parties. On the one hand, the European Union is happy to regulate markets through soft law, because technically speaking, soft law enables the European Union to regulate markets that fall within the competence of the member states. And on the other hand, national actors, so administration and judges, are quite happy to receive such a guidance from the European. Let me close my my presentation. Do I still have some minutes? 3 minutes. Thank you so much. With accountability issues. So we can split accountability issues in two parts. We can focus on the purely accountability questions like transparency, access to documents, participation of interested parties. And from that perspective, it's quite difficult to sketch a map, because the map is really fragmented. Each agency, there is no horizontal legislation covering this field, leaving aside, of course, regulation 1049 on the documents. And many proposals have been done so far. I'm referring to renewal, so the model rules on new administrative procedures, so as to give a more horizontal regulation of these aspects, but so far nothing has been done. I think that an interesting point, an interesting idea on which be reflected is the use of independent accountability mechanism. Independent accountability mechanism are internal ombudsmen, which are quite often used within the European Investment Bank, but also the International Investment Bank. So they are internal ombudsmen, and they can check from an internal perspective whether the institution as such is respecting the principle of good administration. Of course, it's tough to create a cooperation between this internal ombudsman and the general European ombudsman set forth by Article 228 TFU. But on the other hand, creating such internal ombudsman could give the possibility to have more information, because of course the problem for the European ombudsman to some extent is to find the documents and to find the information. I will finish and I will use my very last minute talking about purely judicial protection. Here the problem with judicial protection, in my view, are the following. Of course, it's extremely tough to review the acts adopted by European Union agencies, because EU agencies adopt soft law, as we have mentioned, and they do adopt preparatory acts, and that's particularly true in the case of EASO. Moreover, judicial protection is multi-level with regard to agencies, because of course EU agencies participate in administrative proceedings that stands between EU and national law. Here, I think that something interesting that should be highlighted is the very recent judgment of the Court of Justice in the case FBF, Fédération Bancaire Française. It's 15 July 2021, according to which, for the very first time, the Court of Justice has stated that national judge can refer to the Court of Justice a preliminary ruling on the validity of non-binding acts adopted by European agencies. The European agencies in that case was the European Banking Authority, the soft act was a guideline, and the Court of Justice has stated that the validity of a soft act can be reviewed by the Court of Justice within a preliminary ruling procedure. Of course, this does not cover all the problems that may arise in this field. The second kind of problem that arises in the field of judicial protection is the lack of technical and scientific expertise of judges. These happen quite often with all the European Union agencies which do not fall within the area of freedom, security, and justice, because they perform quite technical roles in the field of aviation safety, railway safety, food safety, so very technical and scientific things, or banking regulation. And of course, then national and European judges do not have the necessary knowledge and expertise in these fields. I don't think that this happens in the field of area of freedom, security, and justice, because over there, the problem is the lack of information. So it's difficult to find information of what agencies is doing. It's not a matter of lack of knowledge. However, I think that we can discuss, and I will finish on this point, we can discuss to what extent the experience of the Board of Appeal that have been established so far in at least 9 agencies to review the validity of EU agencies can be brought also in the field of the area of freedom, security, and justice. Board of Appeal, very briefly, are internal mechanism of review. They are not judges, so it's not a judicial mechanism of review, it's an administrative mechanism of review. However, they are fully independent from the agency, and they give the possibility to individuals to review with a first instance review the validity of the action performed by the agency. And in this regard, the Board of Appeal are made by experts of that specific fields, and they are internal to the agency. They are independent, but internal to the agency. For these very reasons, they have the possibility to catch a lot of information concerning what the agency has done. It is extremely difficult to bring this experience within the AFSJ agencies, mainly Frontex and the EASO, but I think that something can be done, changing a little bit this paradigm. Thank you so much for your attention and attention.
Many thanks, Jacopo. I turn immediately to VALSAMIS, who will start focusing on the area of justice and home affairs with a presentation on immigration control and preventive justice through Frontex and Europol. VALSAMIS, the floor is yours.
Thank you very much. Thank you for the invitation. It's a great pleasure for me to be here, to see so many friends and colleagues in the audience as well. And it's a great program, so congratulations to you who invited us and who designed it. And the title was given to me, so you know it was thrown at me and it made me reflect, and I welcome this. What I want to do today is to address this topic that was given to me by doing 4 things. Placing this issue within a broader contextual and theoretical perspective, number 1. say a few things about Frontex, number 2, say a few things about Europol, number 3, and talk a bit about, towards the end, interagency cooperation, because I think that's really very important in the area of freedom, security, and justice, and that's where we have many gaps. Before I do all that, and I promise I will speak only for 15 minutes, I just a comment on JACOPO's excellent presentation on agencies, just to say, and I would welcome also comments in the discussion about whether the orthodoxy that we have in the EU about regulatory agencies is really applicable in all aspects of agencies in justice and home affairs. Because some of these agencies, as we know, those of us who are dealing with justice and home affairs, are different in the sense that they have a wide range of operational powers, sometimes coercive powers, think of Frontex, and their actions have a direct impact on individuals and on fundamental rights. So, so when I was listening about soft law and accountability, yes, to some extent, but how will an operational action by a Frontex agent on the border be qualified? What is the judicial review there? What is the accountability there? What is the judicial review of a Frontex operational plan? So these are live questions. We do not have case law, and we all speculate, but there is an issue of accountability and legal responsibility and remoteness, if you like. And in area of freedom, security, and justice, there is a sense that agencies are hiding behind member states, claiming they do not have direct powers, and vice versa. And we see it quite a lot, I think, in external border control. So, this is a general remark about whether we can have a framework on agencies or not. Now, on my topic, with a very nice title, and a very nice title of the panel as well, I just want, first of all, on the placing things in context and in some theoretical perspective, to come from 3 different, if you like, perspectives into that. The first perspective is the title of the panel on experimentalist governance. And I think that's a very good term to use in this context. It has been developed in political science to denote, if you like, some flexibility in governance and some overreach, if you like, in the extent of exercise of power. And we can talk about implementation in this context. And we will see how, and I will touch upon this in these 2 case studies that I was given to discuss. We can see instances of experimentalist governance, which is linked, I think, to our specific field of migration, with a second big tendency, which has been really theorized extensively, especially by international relations scholars, which is the process that we all know of securitization of migration. And we know that many, many years ago, Didier Bigot wrote about an insecurity continuum, transferring illegality from crime to migration, as it was developed already in the 90s in justice and home affairs. And I think that we should see the agencies in this context as well. So, we have a continuum between migration and security that blurs the boundaries of purpose, of aim, and of powers. And I will focus on this in my remarks on these 2 agencies, because I think when we end up with a very, on the one hand, as was mentioned, on the ever expansion of powers and constant law reform of the regulations on these agencies, new Frontex regulation, new Europol regulation currently being negotiated. So more and more powers, more and more money. But at the same time, we have blurred boundaries of powers and of legality. So, so I think this blurring of boundaries raises very significant rule of law issues, not only accountability issues, but also rule of law issues. So the legal bases are not clear, and the extent of power and of these agencies is not clear, which may lead obviously to arbitrariness and to big gaps from the perspective of individual. The third aspect, I'm not going to say much because you mentioned it in the title of preventive justice or preventive injustice. I think these terms in the field of immigration law, and every day we have something on the news, Poland, Belarus, the Channel yesterday, we have tragic events that show that the key focus of European migration policy is to stop people reaching the external border of the EU. So, this is a highly preventive agenda, and agencies are being used really to promote this agenda, again, via a securitization discourse. And I think that what is interesting, and I will examine both agencies also from that perspective, that the key, if you like, moral panic currently for governments is the labeling of human smuggling as the greatest evil on earth, and that the migrant deaths at sea are only exclusively the fault of smugglers. So, and the role of agencies is reconfigured, if you like, and if you see smuggling justified, anti-smuggling justified initiatives, it can explain a lot. So this is a general context which we can discuss, of course, and I welcome your comments. And I will focus more on the institutional framework of agencies. So I'm not going to focus a lot on operations, but I'm very, very happy to discuss further. So first of all, Frontex. What we see with Frontex is that we have, if you look at the spectrum of the insecurity continuum, we have a shift, if you like, from migration to security. So what we have with Frontex is that we have an agency whose legal basis in the treaty is firmly within immigration law, in the area of freedom, security, and justice. So the legal base of Frontex, just to remind everybody, is Article 77 of the TFEU, which is about border checks and integrated border management, and 79, which is about control of irregular migration. So it does not have a police legal basis. It does not have a security legal basis. So this is a border management agency and a Coast Guard. Yet, if you read the regulation, and I'm sure you will talk a lot about operational experience, you see that already in Article 1, Frontex has a clear security mandate, internal security mandate, and this internal security mandate is also reflected in the articles on its tasks and on its powers. So, there is quite a lot of internal security within the Frontex regulation. I also dared today, something that I rarely do because I get very bored, to go to the Frontex website, and I found there that there is a web page where Frontex is claiming that it supports the Union and the member states' internal security objectives, which is not limited, according to Frontex, to immigration-related offenses, but it extends to all sorts of offenses related to the border, including, and brace yourselves, money laundering and environmental crime. So Frontex itself views itself as a security agency, in a sense, although from a rule of law perspective, in my view, this is quite problematic because it has not been established really as a security agency. And this colors, I think, its activities on the ground. The second part of the recent regulation is the integration, of course, of the within Frontex of the Eurosur legal framework. Those of you who haven't heard of it, it's a risk analysis surveillance mechanism. And again, there, if you read the provisions of the regulation on Eurosur, and we can discuss about what it does in practice, internal security is very, very prominent there, and risk assessment is very prominent there. So, there is a link clearly with prevention there. So, so on Frontex, just a flavor of the institutional framework, an agency which is an immigration agency, but which has security responsibilities and thinks itself, perceives itself, if you like, as a security agency. Europol, on the other hand. Now, what happened with Europol, as you may know, this is the European Police Office. It is Europe's criminal intelligence agency under the model of intelligence-led policing, and its mandate is to extends to a list of offenses of serious and cross-border crime that are listed in the annex of the Europol regulation. Yet Europol, in the pretext of tackling immigration-related crime, has developed specific activities in the field of migration control, and it has established the Europol, the European Migrant Smuggling Center, in 2016. Now, that's really interesting because no one would notice this center. I mean, I don't know how many of you have heard of it, maybe more than I think, because it hasn't been established via legislation. This was in the conclusions of a Justice and Home Affairs Council, which in a sense created a new sub-body within a European agency, and it's worth reading its annual reports. So it has a life of its own. It produces annual reports, and it is there to coordinate cooperation between Europol and member states, but also other agencies, including Frontex. So again, here I think we have this informality, which is also a characteristic of European migration policy recently, in the context of a shift from the other side, from security to migration control, foreign agencies such as Europol. And I think that's very interesting. And for those of you who want to hear more, there is a very interesting report by the European Court of Auditors, published last September, I think, on whether Europol is effective in the fight against migrant smuggling, as if, this could be necessarily the priority for Europol, which deals with terrorism, drug trafficking, organized crime, and so on and so forth. And in this report, the Court of Auditors, I think that's manna from heaven for Europol, I think, if it wants more powers, because the report says that there should be further avenues of collaboration and data exchange between Europol and other agencies, such as Frontex. There should be interoperability also within the systems. But I think one wonders there, what is really, where does purpose limitation go in this context? These are different kinds of agencies with different kinds of mandates. They are not the same, and it's not all about security. What is interesting is the European Data Protection Supervisor some years ago found that transfers of data from Frontex to Europol were problematic, and this is why the new regulation on Frontex was amended to include a direct legal basis enabling exchange of data. But there are many issues with data protection, but also with interoperability, which I'm not going to talk about today. Finally, and what exacerbates, I think, this rule of law deficit and this accountability deficit, also as applied operationally on how these agencies work on the ground, is the big push towards interagency cooperation. And interagency cooperation currently seems to me that it's happening without any accountability and with very minimal rules. I mean, there are rules on individual regulations of Europol, Frontex, how they work with each other, but there are examples of multi-agency cooperation on the ground where, the actual scrutiny of the operations is really very minimal. And I will close with an example on that, which is a parallel trend towards the militarization of border control in the EU with Operation Sophia and UNAFOR Med. And if you see what happened with Operation Sophia, at some point you had a multi-agency information exchange between the military mission, Frontex, and Europol in order to address migration flows in the Mediterranean. So you have three different layers of border control with different missions, different powers, different competencies, all working together in a way where it's difficult to control. So to sum up, in the name of prevention, I think the big question is whether experimentalist governance is there as a flexible way to achieve more effective migration management or as a threat to the rule of law. I will stop here, but I very much look forward to the discussion.
Thank you very much, Valsamis, for the picture that you offered along with JACOPO. Yeah, we have quite a complex picture that becomes more and more complicated the more we go, the more we zoom in and look at the specific acts and operational activities of the agencies. So we have a general problem, which is the lack of a legal basis and the resulting problems of accountability, but we also have issues related to the day-by-day operational activities of these agencies, in particular in the field that is privileged in our analysis, and the area of interagency cooperation looks really worrisome in a way. Let's hear from the public if there are questions. I think we have at least 15 to 20 minutes if we want to do for the discussion. I kindly ask those who want to intervene to raise their hand, just like Daniela is doing, or write down a question in the chat. Please, Daniela, the floor is yours.
Thank you very much, Mario, and let me thank both our speakers for setting the tone for a very fruitful discussion on evolving paradigms of these agencies, these security agencies. I would like to pose two questions, one each. To Jacopo, I would like to ask you to elaborate a little bit more on the possibility to export the functioning of borders of appeal to AFSJ agencies in the perspective of reducing the deficit of informal accountability. So to what extent, in your opinion, does all forms of informal decision making does those forms of decision making be impacted by this type of independent but internal control? And to Professor MITSILEGAS, I would like to ask you about the processes of digitalization and automation of border controls in the perspective of your big picture, because you have, of course, very convincingly maintained that they can be considered groundbreaking changes, in the processes of border management. The way in which they put to the test the limits of the law in addressing the impact of surveillance technology on the rights of effective individuals can let us to conclude that we have to search new avenues of redress. And could we found those avenues of redress in international cooperation among different oversight actors and fora, or it would be better to, in your opinion, to further extend the qualification of effective venues of justice to extrajudicial mechanisms such as those recalled by JACOPO. So for instance, ombudsmen and other sort of extrajudicial ways. Thank you very much.
Many thanks, Daniela. While we wait for other questions, maybe Jacopo and VALSAMIS wants to address your question.
Yeah, of course. Which order?
Jacopo, you go first. Thank you.
Okay, thank you so much. Thank you, Daniela. It's a pleasure to come back on this point, and I think it also tackles the point that was raised by VALSAMIS. If I can also briefly tackle what VALSAMIS was referring to. So let's start with Daniela's question on the boards of appeal. I think a full article could be devoted to this topic, and some articles have already been written on that point. Why boards of appeal could work also in AFSJ agencies? Well, first of all, it depends on what you mean by board of appeal. I think that current board of appeal could help perhaps in the field of EASO, because EASO does take some decision. I think that the problem with Frontex is that Frontex, and I think that was what VALSAMIS was pointing out, Frontex takes actions. It's a very, it's not only an operational agency, but it also works on the ground. So you have to really tackle something that is done by Frontex staff. So with regard to Frontex, I think that the Board of Appeal could help if and when it will be possible to grant to the Board of Appeal the power to scrutiny also action for damages. Nowadays, it is not possible. There is no Board of Appeal having such a competence, such a prerogative, but many legal scholars are arguing in this regard. I think that from a purely legal perspective, this cannot be done, because you got a legal basis in the treaties, Article 263, paragraph 5, that enables the legislator to delegate judicial powers from the Court of Justice to Board of Appeal just in the field of action for annulment, but not in the field of the action for damages. However, in the Board of Appeal of the European Railway Agency, has received from the legislator the power to receive appeal for the failure to act of the agency. And if you take Article 265, you won't have any legal basis to such a delegation of judicial prerogatives. So if this has been done in the field of failure to act, I think it can be replicated in the field of action for damages. Moreover, well, I will not make it so complex, but if you take the very old Council Legal Service opinion before the amendment of Article 263 for the establishment of the very first Board of Appeal of the European Union Intellectual Property Office, at that time it was thought that you do not even need an amendment of the treaty because Board of Appeal simply assessed the facts and not the law. And for this very reason, you can delegate the assessment of facts and not of the legal aspects of an issue to external bodies other to the Court of Law. So to make a long story short, with regard to Frontex, I think that an internal Board of Appeal having the possibility to challenge action for damages could actually enhance the possibility to hold this body accountable. Because we all know how difficult it is to appeal before the Court of Justice, according to Article 268 and 340, because we know that the case law of the Court of Justice is quite limited with regard to the action for damages. But once you delegate these powers to a Board of Appeal, then you also have the possibility to change a little bit the case law and to adapt that case law, that condition to the specific environment in which you are in. As with regard to EASO, it depends on what we are talking about. So the current EASO that does simply adopt to some extent what we can call preparatory act, then it will be tough, of course, for a Board of Appeal, because nowadays Board of Appeal do not have any power to review soft law and preparatory acts. But again, also in this regard, the legal scholars are arguing that there is an untapped potential for Boards of Appeal, and these kind of powers could be delegated to Boards of Appeal. Moreover, and therefore for these very reasons, once you untapped this potential, then also in the case of EASO, Boards of Appeal could actually play an interesting role. And moreover, if and when EASO will expand its mandate and directly adopting decision, then of course, I think that the Board of Appeal could play a crucial role. I hope that in this regard, I've also replied to VALSAMIS' observation before.
Thanks, Jacopo. VALSAMIS.
Yes, thank you very much. That's super interesting. Thank you, Daniela, for this question. I think that you will not be surprised to hear that I think that digitalization, as you called it, is a very serious rule of law issue. And I think I can give you many different examples of digitalization that are not exactly the same. So, you know, there are many different reflections of the digital, I think, in immigration control. So, for example, you can think of the use of AI in pre-screening, you know, in the borders. You can think about what happens to Eurosur risk analysis and transfer of intelligence to third countries. You can look at the exchange of data between Frontex and Europol on specific individuals. So these are different things, but I think what is common is really an unease as to how someone can successfully challenge acts and actions, you know, by agencies and beyond. And I think that's not an easy thing, as we see also from the what happens in the field of surveillance, you know, in the field of data retention, you know. So I think that's a field I think that we can learn a lot of lessons from here. And of course, you have this whole debate on interoperability also of systems and databases, which creates an additional layer of opacity and of rule of law challenge, because what do you do when things are connected in a sense? So it is a challenge. I think to your question about extrajudicial or not, I do not really think these are mutually exclusive. On the contrary, I mean, I would argue for strengthening both because there is an interaction between the two. But I'm a bit of a skeptic in terms of this whole discussion of exclusivity of extrajudicial in this field. I'm a firm believer in judicial redress and judicial avenues. And I think there, also at the level of the Court of Justice, a lot of lessons can be learned also from the surveillance field, where, you know, we have increasing litigation on a number of levels. It's not that easy to catch individual acts, you know, so what happens to your data in the system. And I would call on you, Emilio, proactively, but you raised your hand. But so I was about to say that I'm sure Emilio wants to intervene and share his insights on that. So I would say both judicial and extrajudicial. And in this landscape of opacity, it's good to have light and transparency as much as we can.
Many thanks, Valsamis. I have Barbara Costa on the list, and then I will add also a couple of questions myself if there is no one else intervening.
Yes, good afternoon, everyone. But I would like to know who can refer to the Board of Appeal. Actually, I don't know. This is why I have this question. And if another question is, the Board of Appeal is already an institution of EASO, or it is foreseen in the new regulation?
Many thanks.
Those two questions. Thank you.
Thanks. We collect all the questions and then we close with the interventions of the speakers. Emilio.
Thanks, Mario. Valsamis. So I had the chance of following the birth of at least 10 of these agencies. And I can tell you that is like driving in a fog, because every time we invent a new solution, the Parliament, the Council invent new solution. And it's very, very bizarre that the only framework of reference is a non-binding framework, which dates back to the beginning of the 2000s. So it's really unfortunate that now the European Union is developing a sort of parallel world of agencies without any real accountability and real control. On this aspect, I think that there is something which is extremely important. The first speaker was referring to the soft law instruments. These soft law instruments can, in fact, be transformed in something more serious. Let's think about, for instance, to the integrated border management strategy, which is foreseen by the regulation in 2019, but which has not yet been adopted by the Commission. And this is very unfortunate, because the only strategy which now is deemed to be binding for the member states is the 2016 strategy, which was adopted by the Management Board of Frontex. And obviously, this strategy does not cover, for instance, the aspects of fundamental rights protection. And very rightly, Valsamis was referring to the fact that the agencies intervening in the area of freedom, security, and justice have a strong impact on fundamental rights, notably when they are going out of their own founding legal base. Really, Valsamis, I totally agree with you. This is a classical mission creep. Now no one is able to limit this sort of, let's say, magician coming out from nowhere. So first, I think that this strategy should be something which should be adopted by the institutions. Even the new European Asylum Agency has a strategy on fundamental rights. And if you want see a joke, I just sent some weeks ago a request to the director of this agency for the preparation of the new mission of this agency. The reaction was that the regulation was not yet into force, and in any case, they can't give me the documents because this is covered by the protection of the decision-making process. So really, they are very difficult to control, to follow, not only by the citizens, but quite probably also by the institutions. So this is one of the reasons why I think, and I close with this, that the European Union has created a new parallel world of administrative body without creating an administrative legal framework for these bodies to act. And this is something which is really dangerous.
Many thanks, Emilio, for your remarks. I add 2 points that have been already partially covered. One is on judicial, non-judicial review and their effectiveness with the different kinds of activities performed by the agencies. I agree with VALSAMIS when he says one thing is having to cope with regulatory agencies or regulatory activities of agencies which in turn have some administrative bodies implementing one way or another those guidelines and whose acts might be challenged before national courts. A completely different thing is to have agencies operating at the lowest level of the chain without anyone else intervening in order to implement those acts. And therefore, it is precisely the operative nature of those activities which raise the problem, the general problem that Emilio was addressing now. Don't we need a general regulation covering those kinds of activities which might change according to the specificities of the field, but still have the operational nature that with its distinguishing feature of being, you know, at the lowest end of the implementing chain without other bodies intervening and other courts being allowed to review. And the second point is on mission creep and interagency cooperation, the problem of imputation, who has done what, but even before, a problem of ascertaining what has been done in legal terms. So, because there are activities which go beyond the law, what is allowed by the law, what is foreseen by the legal framework at European level. So there seems to me that there is a basic need to reestablish the principle of legality that governs usually, you know, administrative activities. And my question would be here quite provocative. Is this laziness of EU legislative bodies part of the bigger problem, part of a silent strategy that privileges the effectiveness of agencies precisely by not making their activities accountable? Okay, I leave it here to the authors who will have, let's say, 3 minutes each in order to reply. We can do it in reverse order if you wish. VALSAMIS first and then JACOPO.
Thank you very much. Trying to unmute. Thank you. Yes, I share a lot of what has been said, and I think it's true that it is essentially a rule of law challenge. And I think with the agencies, I think what we find, there's a lot of politics behind it as well, and you know, who is hiding behind whom. It's interesting to see that yesterday, when we had this tragedy in the Channel, you know, with the deaths of migrants, I read that today France said that, you know, we need to give more powers to Frontex. So, you know, Frontex appears really as the instinctive political solution. When you have a problem, refer to Frontex. And then Frontex is called on the border. And then, as you said, it's very, very difficult to ascertain what is done. And we see in the investigations on pushbacks in Greece, where we have really Frontex saying it's not us, we don't know anything, and the Greek government saying we don't know really what's going on. So it is a real rule of law issue which needs further scrutiny, and I'll stop here.
Many thanks, VALSAMIS. JACOPO.
Thank you so much. So who can appeal to the boards of appeal? It depends from the establishing regulation of each agency, but to make a long story short, actually natural and legal persons which are affected by the decision taken by the agency. So usually it is recalled Article 263 TFEU, so it applies the same method for applying before the Court of Justice. Therefore, it means also third country citizens, enterprises which do not have any seat in the EU territory. It has already been envisaged in the new European Union Asylum Agency. According to the proposal that I saw, no, it does not seem to be, but I kindly asked to Marcella Cometti, PhD candidate at the University of Ferrara, to correct me if I'm wrong, and that's also the way to thank her for the assistance and the support in preparing this speech. Professor De Capitani was really pointing out an interesting metaphor, a parallel world of agencies without accountability, and then it goes to soft law. I really appreciate those words. I'm also quite skeptical on soft law, but after conducting some researches on the field, I noticed that many actors, at least in the field of antitrust, state aid, and financial regulation, do love soft law. And many agencies have received hard powers. So to some extent, soft powers have become hard. I'm thinking about EBA, ESMA, and EIOPA with the recast regulation a couple of years ago. But soft law is still there because actually soft law is so much loved by the interested parties. I don't know why. I think that's the death of law, but I think I have to accept it. And therefore, I think that we have to find something good also in soft law. Among judges. If you think about it from that perspective, I know that I'm referring to something very far away from what we have discussed today, but there is an entire world out there. If you think how difficult is the relationship between national judges, constitutional court, and the Court of Justice, if you think about a world of soft law where these kind of conflict can be solved on a less, let's say, problematic way, I think that soft law can also bring some something positive in the system. And finally, a remark on what Professor Savino was saying concerning the differences between regulatory activities and operational agencies. I fully share its view. So perhaps I have to, and I use that view to once again put forward the idea of switching the paradigm from an action for annulment, which is the most common action that we think in the EU litigation, from the action for damages. Because with operational agencies such as Frontex, then you don't have any action, any act to annul, but it could be interesting to reverse the paradigm and think about damages that could be made good. And from that perspective, I think that this could be a way through which also judicial protection can be enhanced with regard to those more operational agencies.
Many thanks to Jacopo and Balsamis for their concluding remarks. We have 4 minutes for a coffee break. We reconvene in 4 minutes at 3:45. Thank you very much to all of you.
I think we should resume. Okay, so welcome back, everybody. I'm very excited to chair this second session for today, and I hope you had a good coffee, because we will now dive in a fascinating discussion on two key issues relating to EU agencies involved in migration and border control: the problem of accountability and the implementation gap. Regarding the accountability, much has been said in the first session. I might only add that the problem at stake when dealing with agencies involved in border control activities is a sort of dichotomy in which these agencies are captured, because on the one hand, they can be considered technocrat guardians, because they are expected to convey an independent and efficiently based contribution to an integrated European administration. On the other hand, they can be considered security operators. And in this vest, they are requested to preempt security threats to the Schengen area through operational activities, but also they are expected to export an anticipatory governance of the external borders. Thus, a question for our speakers may be, is this dichotomy amenable to change by virtue of statute reforms, reducing the deficit of informal accountability of these agencies? Regarding the implementation gap, the specific problem raised by these agencies relates to the original scene, which has been recalled by JACOPO at the very beginning of today's conference. And this is the scene of the scant recognition of agencies in the treaty, of course, alongside with the inherent features of the EU executive federalism. These are classic themes of the policy debate, but also the academic debate of agencies, which of course have been explored from different angles and in different legal systems, but which deserve further attention, especially in light of the process of centralization of enforcement activities at the EU level and the emerging role of EU agencies in exercising executive powers within the framework of a joint enforcement activities. This is surely the case for Frontex, so for the EU Border Agency, but in prospect, it could be also the case for the new asylum agencies on which we have eventually a compromise agreement. We have two excellent speakers who will deal with these dilemmas and challenges stemming from this scattered and multi-actor operational context. First is Marco Stefan, who is a research fellow at the Center for European Policy Studies and co-editor inter alia of an interesting book on fundamental rights challenges in border controls and expulsion of irregular migrants. And Marco will look today at the existence and effectiveness of compliant mechanisms that can be activated when fundamental rights violation happen in the context of joint operations at the external borders. Our second speaker is LILIAN TSOURDI, assistant professor at Maastricht University, who has extensively and eloquently written on the evolving role of EU agencies in the administrative governance of asylum and external border control. And Lilian will deal today with a central development in these respects, which is the reform of the European Asylum Support Office. Many thanks to you both for being with us today. Before giving the floor to Marco, I again kindly invite you all to, if you want, of course, put on your camera to make the conversation more lively. Please, Marco, the floor is yours for the next 15 minutes.
Thank you very much, Daniela, for first of all, the invitation to this conference and also for the nice introduction. As for VALSAMIS, I was somehow given a title to, focus my presentation on. And unlike VALSAMIS actually took the liberty to change the title while I was preparing the presentation. And I reformulated in a way that really, I think, makes it relevant to address, in particular, the first question. So the one related to accountability. In fact, my title for the presentation will be Frontex, Great Powers with Limited Fundamental Rights Accountability. And bear in mind, this is not a question, this is actually a statement. And I'll try, maybe too confidently, to actually prove that this statement is actually, correct by analyzing indeed the type of administrative mechanism through which responsibilities for alleged fundamental rights abuses linked to action or inactions by the various EU and national agencies participating in Frontex operation can be investigated, ascertained, and followed up. Now, before I start, just indeed to recall, as already what was already done by Daniela, that this presentation actually based on prior research work conducted really on and focusing on the role and responsibilities of Frontex in addressing the fundamental rights accountability challenge that arise in the context of EU border control, border surveillance, and returns operation. So, in terms of before really going into the actual analysis of this administrative mechanism that are now exist and that are designed, in fact, to allow people who feel that their rights have been abused in the context of Frontex operation, it's worth taking a step back and really looking at briefly at how Frontex powers and responsibilities have evolved over time. It was already mentioned that there's been a number of recast of the Frontex funding regulation, the last of which occurred only in 2019. In 2020, this regulation actually entered into force, and it came to, it basically granted to the agency a wide range of new powers. So now, basically, Frontex is not only responsible for strategic and coordination tasks, notably tasks that involve the coordination of a wide range of different national authorities that are responsible for performing border guard, border control and border surveillance function, but also coordinate a number of and cooperate with a number of other agencies established in the area of freedom, security, and justice. EASO, Europol, Eurojust, and EULISA, for instance. But also, for instance, other agencies, such as agencies that are responsible for maritime safety and maritime surveillance. But let's say coordination and cooperation powers of Frontex goes even beyond that and extend well into cooperation with third countries. This means that basically Frontex has now become the epicenter of an interoperable system of European integrated border management, which relies in fact on indeed a multi-actor operational framework, but also on very much on intelligence-led border surveillance and data-driven policing of migration and asylum. In addition to this already quite extensive task, Frontex now also have been entrusted with the operational tasks and executive powers, and this has already clearly been mentioned in the previous panel. So the regulation from 2019 basically established a standing corps, which is supposed to be at some point composed by 10,000 border guards, some of which will also be able to carry weapons, okay? In addition to that, Frontex is also, and this is a big victory, has been a big victory for Frontex, something that the agency have asked for a long time. Now, the agency will also be able to purchase and deploy its own equipment, including vessels, vehicles, aircraft, drones, radars, and all sorts of technology that are being currently deployed in the field of border control and border management. It is interesting, really, to give a flavor of the type of agency that Frontex has become through the reform introduced indeed with the last regulation, to recall a statement made by the executive director of the agency before the European Parliament in March 2021, when in fact it clearly stated that we are a fully fledged EU agency, no doubt about that, but we're also a more fully fledged European law enforcement force. Okay, and these really are the words of Europol, of Frontex executive director. Now, with great powers should also come great responsibilities. Okay, and in fact there is some reference, in fact, to the new responsibilities that should come along this expanded operational and coordination task that has been entrusted to Frontex by the 2019 regulation. In fact, already in the recitals of this regulation, it is tracked that with expanded operational task, in particular, that should be strengthen fundamental rights, safeguard, and increase accountability and liability. Okay, so this is clearly stressed in the regulation. Now, how this increased accountability and liability should be operationalized? There are two different ways, but complementary, of course. The first is the monitoring of compliance and detection of deviation from the standards, normative and operational and professional, that applies to all Frontex operation. And for this, of course, there's actually one of the tasks that Article 10 of the new regulation entrusts upon Frontex is to basically ensure human rights compliance during operation. This is expressly mandated to the agency. In addition to that, there is a number of reporting instruments that basically are designed to allow for these deviations or potential abuses to be reported to the hierarchy, so to the responsible bodies of Frontex, and there are a number of them. I can only mention some. The first one is basically for every operation that should be specifically tailored reporting mechanism. The coordinating officer has specific obligation to report on serious incidents occurring in the context of Frontex operation, and of course, then we also have the fundamental right officer, who's in fact responsible for indeed monitoring all activities of the agency, supported by a number of fundamental right monitors, another innovation brought by the 2019 regulation. Now, this is related to the monitoring. When it comes to the verification responsibility and following up, there are also, let's say, obligations that are that the agency currently has. The first one, of course, which comes to mind is the obligation that derive from the implementation of the new complaint mechanism, and this will be basically the core focus of today's presentation. But also, there is a power which is granted to the executive director to suspend or terminate activities or funding thereof in case of serious and persistent violations. Okay, so now these are, let's say, formally and in principle, what are the instruments that the agency has to monitor, detect, investigate, and eventually redress abuses. Okay, now again, this sounds, these are innovation to some extent brought by the new reform. And what I will try to do today is really to explain or display how these innovations are currently being implemented and whether there's any shortcoming in their implementation. But before I go there, I would like just to spend a few words on the specificities of the Frontex activities. And this was basically just this. I think important to complement what already has been said and maybe add a bit of details. It has already been said, in fact, Frontex operational activities have a direct impact on fundamental rights and migrants and asylum seeker. And the more both EU and national authorities participating in Frontex operation go out in the field, the more they encounter actual individuals, which expose them to greater risk of fundamental rights abuses. Secondly, the hybrid natures of Frontex operation, which still combine an intergovernmental and supranational nature. And basically, where we see, in fact, Frontex staff cooperating or coordinating national authorities, and they do so, which actually take place, these operational activities in out-of-sight operational context. So contexts which are in fact, really maritime, or so blue or green borders that are from the public view, from scrutiny to a large extent. And this is compounded, in fact, by a high degree of secrecy of Frontex operation. So Frontex operation, the actual division of work between the wide range of authorities that take place in these activities, it's actually kept secret. It's not publicly accessible, all right? So these are all like specific challenges that needs to be taken into account when looking at the functioning and at the design and functioning of, let's say, the accountability mechanism that has been that the Frontex has been equipped with. So let's now focus on the complaint mechanism. How does it work? Well, I mean, just maybe the current version of the complaint mechanism, it's actually a revamp of a previous version that was introduced by ECB, European Border and Coastal Regulation of 2016. This specific version, which has been introduced only in 2016 after numerous recommendations, including from the European Parliament and the European Ombudsman, had been widely criticized because of its lack of structural and functional independence, because of lack of appropriate follow-up of complaint actually addressed to the agency, and then also widely criticized because of a limited availability and accessibility of the mechanism. And this, I mean, indeed, there is a quite vast literature really explaining how these key criteria that are basically essential to make a complaint mechanism, which is indeed an administrative redress mechanism, effective in light of existing international standards. So it's actually interesting to look at how the regulation from 2019 addressed or proposed to address these shortcomings. So before going there, maybe worth remembering that in fact, despite the regulation being adopted in 2019, there's been major delays in operationalizing this complaint mechanism. And why so? Well, first of all, because I mean, it took 13 months to ensure that the actual management board could adopt the rule of on the functioning of the fundamental rights officer, including the rule of its independence. So there's been 13 months that actually passed since the adoption of the new regulation. And even more time, so 16 months actually elapsed in order to complete the procedure for appointing the fundamental rights officer, which actually has in turn resulted in delays in appointing the deputy fundamental rights officer. Now, these bodies are now being appointed, but because of these delays, the European Ombudsman actually opened in June, opened a new inquiry on, again, the complaint mechanism of Frontex that actually was concluded in July 2021. And it is interesting when looking at the new, complaint mechanism to look at also at the assessment made by the Ombudsman, which actually looked precisely again at the independence, effectiveness, and transparency of this tool, accountability tool. So let's start from the independence. First of all, it should be made clear that in fact this mechanism remains an internal procedure managed by bodies which are part of the agency, so the fundamental rights officer, the executive director, and also member state authorities that actually are supposed to play a big part in the procedure when this concerns their own authority. So it is indeed a mechanism which is not institutionally distinct from Frontex, and as such cannot be qualified as an effectively independent remedy in light of established international and EU standards. Okay, so this should be said from the outset. Now, this is not. It doesn't mean that, of course, it is not important to have a complaint mechanism internal to the agency, and the Ombudsman actually identified some improvement in this respect, with regard in particular to the independence of the fundamental rights officer vis-a-vis the complaint mechanism. In fact, contrary to what happened by virtue of the previous regulation, now the fundamental rights officers do no longer report directly to the executive director, but as long as the functioning of the complaint mechanism is concerned, it mainly report to the management board. And it does so in cooperation with the Frontex Consultative Forum. However, it still remains the fact that all complaints that the fundamental rights officer actually receive must still be sent to the executive director. Okay, I will probably need to shorten my presentation. Anyway, so and another shortcoming when it comes to the introduction is that in order to be indeed there's only limited resources available. In fact, this fundamental right monitor that were supposed to help the fundamental rights officer to independently pursue its activities with regard to the complaint mechanism had not yet fully been appointed. So the lack, again, of sufficient resources. Now, when it comes to the effectiveness, there are key shortcomings even there. So indeed, when it comes to the follow-up to complaints that are addressed to the complaints that are raised because of fundamental right allegation that concern Frontex staff, still the final say is for the executive director. Now, there has been an improvement there, meaning that in fact now the executive director decide not to follow recommendation from the fundamental rights officer, but that decision not to follow may be challenged before the European Union Ombudsman. Now, when it comes to the effectiveness of the complaint mechanism, when it comes to complaints against member states official, here there are still a serious implementation gap. In fact, again, there's no guarantee that the actual authorities responsible for reviewing the merit of the complaint, should the complaint be deemed admissible by the fundamental rights officer, are actually independent. And in fact, there is reportedly very limited information between, and I conclude, between the limited cooperation between Frontex and the member state authority responsible for following up on the complaint. So there's very, again, in terms of implementation, there's a major problem. Also problem of accessibility, although some improvements have been made, but of particular concern and against the Ombudsman recommendation, still there's no possibility to oral complaints, nor there's possibility to, in fact, to submit complaint anonymously. Now, when it comes to maybe some ideas on, on how to address this the shortcoming, eventually necessary to increase independent monitoring of activities on the ground. So really include monitors that actually participate in systematically in Frontex operation, monitors that are independent, that can report on incident, where actually the current system really rely on the member state authorities deployed on the ground. And then indeed, independent follow-up and review. First of all, obligation for the executive director to justify inaction where abuses are reportedly are verified. And secondly, where these abuses are verified, indeed establish a better connection between this internal mechanism and external avenues for judicial administrative redress. Thank you very much.
Thank you, Marco, and sorry for being a little bit strict, but we have been instructed to keep time. So thank you also for the provocative reflection on the gaps in Frontex accountability, but also highlighting improvements. This is, of course, a trend that seems to require the development of new avenues of redress capable of ensuring a sort of portable justice. I imagine there would be questions from the audience, but we have to stick to the program, and thus, without further ado, I move to our second speaker. Please, Lilian, the floor is yours for the next 15 minutes. Thank you.
Thanks so much, Daniela, for the kind introduction. Many thanks to Mario also and the entire team at the team for the invitation. And it's such a pleasure to be also among such a learned audience, because I've been looking at the names and the faces, and these are also experts who are writing and have published widely in this field. So I very much look forward also to the discussion. I do have a PowerPoint that I would like to share with you. You mentioned, Daniela, that this would be possible. You have already enabled me to do so. So I will...
Yes, you are.
Yes.
Okay. So indeed. Right. So I will be focusing my observations on the European Union Agency on Asylum. And as Daniela mentioned, this is one of the first pieces of the pact that has fallen together. We will see that this has been, of course, through a very specific compromise, but we do have a renewed mandate for and a European Union Agency on Asylum that was voted in favor in the EP plenary around the 11th of November. So very much recent developments. And I will be looking also, as Daniela mentioned, on the operational involvement and implementation, and also on monitoring and steering functions. And the reason why I have this PowerPoint is because I will be doing so with some comparative highlights, which will only be visual for you. So I will not be expanding on Frontex, but in whatever I will be actually analyzing, you will be able to have parallels with Frontex at the other column, because I think that this is quite useful for our discussions in understanding what has happened actually and what are the limitations also of this new, as the Commission mentioned, agency. So we do not have any pronouncements of asylum, let's say, and the implementation of asylum being a shared responsibility, if you want, between the agency and the member states, as we have with Frontex. So it is a bit of a more reticent approach in terms of its operational capacities. We do have a sort of a reserve pool of 500 people, which is impressive compared to the realities of EASO to date. But it fares, of course, quite weak if we think of the 10,000, let's say, core of Frontex. So indeed, the operational involvement is foreseen per definition as something more limited, even if we have these 500 persons ready for deployment, plus some expansion of own staff foreseen. What has remained heavily circumscribed, and this is in fact a compromise compared to the initial more actually ambitious proposal of the Commission, is its de jure role in asylum processing. This is still mentioned as facilitation or as assistance, and it does not reflect actually current administrative realities on the ground, where since 2016, for example, in Greece, we have much more intense joint implementation patterns where agency deployees are not just assisting, but they are independently conducting part of the processing, emitting an advisory opinion, which is quite authoritative. Of course, it is up to the Greek authorities to adopt the final decision in terms of the result, let's say, of the asylum processing. But the agency deployees are active both in the admissibility and in the merit stage. This had been also in the literature pointed out, but also in a complaint before the Ombudsman. It had been pointed out that this had been happening in a legal vacuum. In essence, it is regulated by Greek administrative law, but it is beyond the mandate of EASO, and it is still, even with the new regulation, it will not be, we see the reticence of the member states. It is not fully addressed because the wording that has been included here still does not reflect actually the operational involvement on the ground. And in another piece, I have actually analyzed how this also reticence is reflected in other instruments of the pact, which are under negotiation. which do not reflect actually the current operational role, neither of EASO nor of Frontex, or reflect what are the procedural, let's say, and fundamental rights implications that come from this increased operational role. We heard before, greater powers, greater responsibility. The law doesn't seem to be catching up yet. In terms of its role in monitoring, this is part of the compromise that I mentioned, because one of the great innovations was this new monitoring mechanisms that mirrored actually the vulnerability assessment that Frontex undertakes. This started very ambitiously in the first Commission proposal as in essence monitoring of the implementation of the CEPS. It was circumscribed to operational and technical application, etc. So to mirror more what is happening in the vulnerability assessment. But of course, these so-called technical elements can never be, let's say, fully separated from the realities on the ground and from actually the implementation of the asylum system itself. Once a country has, I don't know, 500 beds for asylum seekers and it has 10 or 15,000 asylum seekers, it becomes clear that from this element we can draw a lot about actually the implementation of CEPS itself and violations of fundamental rights, even if member states did not wish it to be so. And this mechanism is quite complex, and through a gradation of measures starting from recommendations within the management boards, then the European Commission is involved, and finally the Council could, through an implementing act, mandate deployments on the ground in the same way as it is happening with the vulnerability assessment in Frontex. So this was a rather controversial element. It was blocked specifically by the Mediterranean countries, the Mediterranean 5, who said that we are not to agree to these extensive monitoring powers before actually we see concrete progress on the solidarity elements, which of course are not included in this instrument, but are scattered around different instruments in the pact. So they froze, in essence, the application of the majority of the monitoring mechanism until 2024. In 2024, monitoring is to begin, but without teeth. So the teeth, this gradation of measures that I mentioned, will only become operational once it is mentioned that the let's say, successor to what is now the Dublin regulation will be in place, and all the related solidarity measures. So quite a unique solution in order to be able to close this file. And then there is something that is less known, the so-called steering functions. These, again, as you see on the left, are much more evolved and pronounced in the case of Frontex. Here, what we have is the so-called common analysis and guidance notes, which relate to country of origin information, which are actually co-produced by member states and the agency, but they are endorsed by the management board of the agency. So they are not legally binding, but they will be authoritative and they will influence decision-making on asylum, and specifically these guidance notes will relate to very sensitive, if you want, caseloads. So they will have a great impact. They will look into evolving situation, and they will influence also rejection of claims and return. Of course, there is this wording that again mentions that this has nothing to do, it's without prejudice to the competence for deciding in individual applications. Again, the Commission was much more ambitious in the initial proposal, and it had mentioned about an obligation to take them into account, and even member states to give statistics whenever they didn't take them into account and to justify why. All of this has been removed, but still they will be authoritative and they will have this kind of steering potential. So their quality in terms of independence of sources, in terms of being, let's say, often updated, in terms of some external control. So where there is country of origin information being produced in member states or in countries that had a lengthy tradition to produce these notes, there are always sent for approval to external experts. So it's not just done in the ministries, if you want, in order to ensure the quality. So something like that, which is not foreseen for the moment, should be included as we are passing to this authoritative, if you want, products. So if we make an overall assessment of what has happened here, and also the issue of fundamental rights and accountability has featured in the discussions already quite intensely. So there were already a number of accountability, let's say, processes and mechanisms reflecting developments in Frontex. We have some, let's say, developments that look like a step back. So they look a step back, a step forward for EASO, but a step back compared to what has happened in Frontex. They mirror the 2016, if you want, regulation of Frontex. There is a fundamental rights officer, but more of a lone wolf or Wolverine. So they won't have this team of return monitors, of fundamental rights officers that are now foreseen in Frontex, which of course brings to the point how much can then one individual that will have a small office achieve, as was the case previously with the fundamental rights officer of Frontex. There is an individual complaint mechanisms, but again, it presents mainly the 2016, if you want, characteristics of the one of Frontex. So things are moving gradually. We are one step behind, not only operationally, but in terms of fundamental rights guarantees. And then there are some other, let's say, there is this tension between the operational role, so this joint implementation, and the fact that at some point, eventually, monitoring is to take place, as in essence, we have the same, if you want, actor who will be jointly implementing and then who will be called to monitor capacities and also indirectly implementation of asylum obligations in a member state. So there, of course, there is a tension with independence, let's say, and the level of scrutiny of its own activities and how they impact on implementation capacities or fundamental rights. This relating to the issue of fundamental rights and accountability, we also see this ambivalence in operational involvement. So even the new regulation, there is a reluctance to portray its operational role, and it is also not fully reflected, as I mentioned, in the pact. So if one looks at the border procedures or the screening regulation, these are processes where currently EASO and Frontex are very much active, let's say, in the implementation of the hotspot approach to migration management. And they are almost an afterthought if one reads these texts, and nothing is done, let's say, to reflect or procedurally and in terms of fundamental rights protection, what their involvement means or how the text should change to reflect all of these joint processes. And then there is the more broader question: should we aim for more administrative integration or not? That we can also discuss with the public. I have always mentioned both orally and in my literature that administrative integration is neither inherently positive nor inherently negative. It's more like a tool, a weapon, so it depends on what we do with it. And it depends on the safeguards that we are going to build in. It depends also on the policy direction. Of course, if we just say there will be more administrative integration targeted to operationalizing externalization, that is a policy choice. Then the issue is not so much with the administrative integration, but with the policy flair and direction that we have turned administrative integration to. We could also turn it to making processes more effective and ensuring the fundamental rights of asylum applicants and migrants. So far, though, the signs are not so, let's say, optimistic, given the fact that this administrative integration, let's say, framework has not been properly, let's say, reflected in all instruments. And even in the instrument of the Asylum Office itself, we do see some steps forward, but it is not clear if we now already see what is happening in Frontex and why it was necessary to strengthen these mechanisms. It is likely that the more weakened version of this mechanism, that is like a generation back, will not be able to yield the necessary results. So I stop here and I look forward to the discussion.
Thank you very much, Lilian. It was really inspiring, this reflection on the mandate expansion of the asylum agency, which served also to set the scene for your cool-headed analysis of the real dimension of the change prompted by the reform. Very interesting from my side, in particular the position of the Med5 on the trade-off between the lack of solidarity measures and the strengthening of the monitoring mandate of the new agency, in a way revealing the at least perceived rationale of the new supervisory powers of the agency as watchdog of the respect of Dublin acquis, and so further pardoning the position of frontline member states. But it's time now to for the discussion, and we have plenty of food for thought. So I invite those of you who wants to intervene to raise your hand or type in chat so we can collect some questions before giving back the floor to our speakers. Okay, Mario, and then Salvo, please. Mario first.
Okay, many thanks to both of you for your very systematic presentation, which helped us a lot in order to you know, clarify the kind of issues that we face with regard to the two agencies you have examined. I start with questions for on EASO, and therefore for Lilian. Can you tell us a bit more about the actual role played by EASO in the context of what you call joint implementation? I assume you refer to the role played by EASO in the examination of applications, and can we say that EASO opinions are somewhat substantively final or binding to administrations like in Malta or Greece, where EASO is involved in this kind of assessment? And this is my first question. The second question is more related to the future and to your last question. Should we aim for more administrative integration? I acknowledge it is neither inherently positive nor negative, but still we face a reality in which the average level of acceptance or rejection of application varies enormously between member states. So if we were in a rational world, which is not the case, of course, we could foresee a development of EASO that might be similar to the one of the European Central Bank, meaning an agency taking the lead of a almost federal administrative setting, with EASO leading and national administration following the guidelines, instructions of EASO in order to harmonize the practices and also the results of the assessment carried out with regard to national implementation. This would have an enormous impact on secondary movements, for instance, and therefore I would see, and it would also relieve enormously the Med5 southern member states in the actual, carrying out of activities without proper guidance or with a bit of confusion as to the standards to apply. So I wonder whether we can foresee a sort of regulatory future for EASO leading this sort of federal structure, administrative structure. I'll stop here.
Sorry, thank you, Mario. Salvo, please.
Thank you very much. I'm very happy to see online so many colleagues and friends. And actually, my question builds on the question that Lilian put at the end of her presentations and on which Mario has already followed up. So shall we aim to more integrated administration? I think this question about administrative integration portrays a situation between the devil and the deep blue sea. And I would like to propose actually a test to both the speakers, so also Marco Stefan. My question is, who should or will benefit from this administrative integration? Will this be the member states? But in this case, I think that the statutory framework should clearly state the allocation of functions, if we don't want to use the expression of competence. Shall perhaps this be the migrants, but then we need to make sure that the migrants have clear remedies, clear avenues for access to justice. So based on this test, on which I would like to invite you to reflect whether it makes sense, so whether you think we shall aim to administrative integration, provided this is beneficial to one of the two. I then ask, what do you suggest for the future in terms of improvements, especially from the perspective of the migrants? Well, this is perhaps a separated questions, but yeah, thank you.
Thank you very much, Salvo. I take the privilege to add one question for you both, to Marco. It is about the complementarity between extrajudicial supranational redress tools and national administrative appeals, because I saw you, your bright eyes when we were dealing with this issue in the first session. So my question would be, which are the elements of in your opinion, of similarity, or at least what is the legal relation between Frontex compliant mechanism and the right to appeal administrative decisions based on immigration and asylum law and entered by EU member states? So similarity and differences and, in the prospect. To Lilian, my question would be about the involvement of EASO, so the new asylum agency, in processing asylum claims, and especially within the framework of composite administrative proceedings. Could you please elaborate a little bit more on the elements of common processing ingrained in the new mandate? in the prospect, of course, of joint processing, and whether they are suitable for limiting the expanding de facto powers of the agency. Okay, I will ask kindly the speakers to reply in reverse order. So Lilian first.
Thank you all for your questions. There was also a question from Agostina Pirello that I saw in the chat.
Thank you very much for pointing out. Let's also join this question. I will read it. I have a question regarding the monitoring mechanisms in EASO. In your opinion, why was not a system like the Schengen evaluation system put in place to evaluate asylum systems? Okay, I think
I will also address this. So starting from the first remarks, you are right, Daniela, that actually the Mediterranean states did actually perceive that the monitoring mechanism would have teeth, and that's why, especially in safeguarding, let's say, the implementation of the current Dublin acquis. So they said, unless we have a revamp of Dublin that we perceive as more equitable, we do not agree to this additional and more intense monitoring powers. So despite the formal language of technical elements, etc., they were aware that, and they believe themselves that there is more at stake. Then Mario, you asked me about the actual role. So there is no, the intensity of joint implementation for now was just regulated by national legislation. So wherever we have this involvement of EASO, it also differs from member state to member state. In Greece mainly, and a bit in Cyprus, it is more involved in this more intense way that I described, with independently undertaking part of the decision making and emitting an advisory opinion. In Italy, for example, it has really a more advisory role, so it is not directly involved in the same way in processing. So there is also not one clear picture of what is happening operationally on the ground, because it is a patchwork of what each national law has allowed the agency to do beyond its current mandate. Let us be clear also on that. So its opinions are authoritative, but at least the experience of Greece, but not substantively, if you want, because you say, are they substantively binding? So in Greece, we have had the first instance authority in the past, significantly overturning decisions of EASO on admissibility, which were actually the EASO advisory opinion is that, okay, this should be inadmissible. We can return these individuals to Turkey through the EU-Turkey deal, whereas it concerned non-Syrian applicants. And as you may know, the special protective framework that exists, this kind of temporary protection that exists in Turkey, was only geared at refugees from Syria. So Turkey retains the geographical limitation to the convention. So what it had on the basis of national law was directed only to Syrians. So the Greek authorities were saying, we cannot return Afghans, we cannot return Iraqis, etc., to Turkey, and they were overturning. Now, of course, there is a new political flair, and there are returns. They are actually, they would wish, Turkey does not accept, but they would wish to have such returns. So just to say, though, in your question, this shows that they were, let's say, influential, but that national authorities still took the time, when they had a different policy and legal vision, to systematically overturn them. And I will come back to your, so now the question that with Salvo and Mario that I will combine together also for the interest of time on who will benefit and also should we aim or not for more administrative integration. Definitely more administrative integration will lead to more harmonization. This is undeniable. And this is one, if you want, of the advantages if we think of further administrative integration. The point is more harmonization towards what? So this is why I said it depends on what is, if there is an underlying policy objective or not. If it was really to uphold the CEAS norms and to make more effective processing in respect of all procedural standards, etc., then you have an alignment between, let's say, more harmonization and higher procedural standards. If, as already some initial warning signs in Greece show, though, you say, I want more harmonization to achieve, to operationalize externalization, and where EASO was actually stating that applications were inadmissible, where it was clear that these individuals would not find protection, and the Greek Asylum Service was saying, well, in this way, I will be conducting refoulement if I send these people back because they will not be protected, then we have a problem because we have more harmonization, but it is not aligning with the higher procedural standards. So that's why I say that it is a tool, it is a weapon. The weapon does not go away. It has this function of creating higher harmonization, of being influential. But the point is where you turn this weapon and what you do with it. So of course, success is in the eye of the beholder. Many governments were saying, we were so happy we have the EU-Turkey deal, so few people are coming, and while Turkey was accepting returns, and now we can return. This has been very successful. But in terms of fundamental rights, protection, if you want, and high procedural standards, it wouldn't be, as Salvo is asking, who will benefit? Will it be the migrants? Definitely not, if it has this this flair that it seems to be having for now. As for the member states themselves, they are reluctant, and this is why they did not, let's say, crystallize it in law, even if it was happening on their ground, for these reasons of solidarity, in essence, because they were saying, until we figure out whether we will have more support, whether we will have some kind of distribution or further support, we are not going to agree to more control, to more, let's say, harmonization, etc., that will mean that large numbers of individuals are just remaining and being processed, let's say, at the border. And the fact that they don't believe that an effective solution will be found is to explain, not fully, because there are many factors, but partially the way that they have also embraced instead externalization and even illegal pushbacks as a way, let's say, to safeguard themselves from what they perceive as this unfairly shared responsibilities. And finally, to your question, to the question of Agostina, so the monitoring mechanism in EASO would have been closer to the Schengen evaluation system, and it was actually, as initially proposed by the Commission, it was actually the member states that wanted to water it down and to make it look more like the Frontex vulnerability assessment, which is happening in parallel, actually, and there are many synergies with the two processes, but it has this language incorporated of looking into the technical aspects just to see if there are the capacities to implement. So they wanted to align it more with this, in the hopes that it would be less invasive and it would have less teeth. But as we saw as well, or in practice for the Mediterranean states, this was still too much, even if it was not, let's say, organized, mirroring the Schengen evaluation system, but more the vulnerability assessment. They wouldn't even have that before they had solidarity. So I stop here.
Thank you very much, Lilian, for spicing it up with your thought-provoking answers. We have 14 minutes left to next session. So Marco, it's your turn. Please go ahead.
Yes, and I will be brief. So I'll start with the question on the similarity between the Frontex complaint mechanism and other form of appeals that apply in the area of border controls and border management. I mean, in terms of, rather than speaking about similarity, I would rather refer to differences. First of all, really the design differences. So when it comes to the complaint mechanism, it is clear from the regulation that this is limited to action or inactions. Okay, so actions that, operative action in the context of Frontex joint operation. When it comes to something maybe to mention, when it comes to inactions, this is an innovative element that the Regulation 2019 actually introduced, the possibility to complain against inaction, which is very much relevant if you think of, for instance, the lack of action of Frontex in preventing specific incidents from occurring, despite knowing that specific practices are taking place at the external borders. The most clear example that comes to my mind is the one of pushback that already been mentioned. Okay, so it's from Frontex. It is well known that Frontex is informed of a certain operative practice. It doesn't intervene. So this is an clear example of inaction against which you can complain. The problem is that the regulation does not specify how to complain against inaction. What is an inaction and how the complainant can submit a complaint against such inaction? This is not specified, not in the regulation and not in the, let's say, operational guidelines of Frontex. So this is something that is missing and is quite crucial because it could bring, indeed, could add value to this system of accountability with all its flaws. Now, this is very different from other instruments that, for instance, provided other pieces of EU legislation, and I'm referring in particular to Article 13, for instance, of the EU Return Directive, and I'm quoting. It stresses that third country national concern by return decision shall be afforded an effective remedy to appeal against or seek review of decision related to return before a competent judicial or administrative authority or a competent body composed of members who are impartial and who enjoy safeguard of independence. Okay, so clearly the language here is different and closer to the standard that, according to Article 46 of the EU Charter, need to be met in order to deliver an effective remedy, which needs to be delivered before a tribunal. Okay, so completely different. So rather than similarities, I would really underline the differences here, and also different functions. Okay, and here it links to the first part, to the first question in terms of the level of integration, here I really see, in fact, when it comes to Frontex, rather low level of integration, especially when it comes to the complaints that are brought against national authorities. Here again, the competence to follow up, to investigate, it relies heavily, if not exclusively, on national authorities. And here we see really huge implementation problems because here an example. These authorities often are the same authorities to which the authorities against which the complaint was brought belong. So this is really, the same law enforcement authorities. So with no guarantees of independence, and there's very limited involvement of independent administrative institutions such as National Ombudsman or National Human Rights Institution. In fact, it's interesting to know that, in fact, in the investigation, the latest investigation that the Ombudsman conducted, it actually inquired with national ombudsmen, first of all, whether they've been informed or forward the complaints concerning their national authorities by the FRA, whether they investigated the response of national authority to such complaints, and whether they received complaint directly about alleged fundamental rights in Frontex. Now, out of the 27 member states, the ombudsman received 13 replies. Out of these 13 replies, 10 replied in the negative to all these questions. Okay, so this is the level of integration. I mean, that there's no, basically, despite the fact that, you know, under EU law, a person whose rights have been infringed in the application of EU acquis has right to, you know, access to remedies at the national level. There's such right is inexistent. Okay, so hence, you know, really the need to, you know, improve monitoring, improve reporting, and better link this internal oversight mechanism with national remedial institution of administrative and judicial nature. Thank you.
Thank you very much, Marco, for you know, your very brilliant answer and putting in the spotlight the limits of Frontex mandate regarding redress mechanisms and the existence of the differences with national administrative systems, and more generally for pointing to the elephant in the room. So the existence of conflicts of interest that make us ask who guards the guardians. So this is a very key question in this field. I think we have time for a brief break before resuming the last session for today. So I leave you for a while, and we will have the last session chaired by Francesco Gatta in, let's say, 8 minutes. Thank you very much.
Thank you.
Right. Welcome back. I think we can resume here our conference. Are we recording? Yes, we are. So good afternoon, everyone, and welcome back to the 4th annual conference of the Academy of Law and Migration. We are now in the 3rd and final session for today, the 3rd and final session, which I have the pleasure to chair. The title of the session is Protecting Human Rights at Sea and at the Borders, the role of the area of freedom, security, and justice agencies. We have 2 speakers for this session, Roberto Cortinovis and TAMÁS MOLNÁR. Welcome to both of you. Thank you very much for being here with us today. Roberto and TAMÁS will help us to better understand and discuss together this problematic issue of the relationship between border controls, border management, and respect for human rights, fundamental rights of migrants. Now, I will proceed swiftly here and immediately give the floor to the speakers, since we have a time schedule to respect. Also, TAMÁS informed me that he has to leave at 6 o'clock sharp. So let's indeed proceed here. Let me just point out that you have 15 minutes at your disposal. As you know, since we have been speaking about Frontex and executive powers, enforcement powers, as a chair, I do have executive powers. I won't use them. I will rather use, let's say, soft powers and use those kind of signals if need be. But I'm sure that you will stick to the time. So let's indeed start with our first guest, our first speaker. That's Roberto Cortinovis. Roberto is a researcher in the Justice and Home Affairs Unit at CEPS, Center for European Policy Studies, based in Brussels. Previously, he was a postdoc researcher in the Department of Political Science at the Catholic University of Milan, Italy. Roberto holds a PhD from the same university in Italy and a Master of Science in Government and Politics in the EU from the London School of Economics and Political Science. The title of Roberto's presentation is Search and Rescue, Disembarkation, and Maritime Cooperation after the reform of the European Border and Coast Guard Agency. So, Roberto, the floor is yours, please. Thank you.
Thanks a lot, Francesco. I hope you can hear me well. Many thanks for your kind introduction and for the invitation. It's great to be part of this discussion, and it's also great to listen from the interventions of speakers in the previous 2 panels. So following your suggestion, my intervention will focus on policy and legal developments, on search and rescue, disembarkation and relocation at the EU level, paying specific attention to the role of the European Border and Coast Guard Agency or Frontex in this area. So part of my intervention will focus specifically on the approach and the initiative that have been laid down in the Pact on Migration and Asylum, currently under negotiation. But before doing so, I will provide a kind of background analysis trying to describe what I consider some of the key dynamics that have shaped EU and member states' action in this area, and also the action of the Frontex agency. I will focus on the central Mediterranean as an example of these trends, but I think some of the points I'm going to make can be extended also to other situations as well. So to start with, search and rescue disputes among coastal states in the Mediterranean are not new, but rooted in long-standing disagreements over the interpretation of their responsibility under international law. What is interesting to note, however, is that in the few years preceding 2015, the focus of EU and member states' key action was on reducing loss of life in the central Mediterranean. The launch of the Italian Mare Nostrum operation in October 2013, with a strong SAR component, was aimed at avoiding the repetition of deadly incidents at sea. However, the approach of key member states, such as Italy and EU institutions, changed quite radically over the following years. The strategy adopted since then was one of progressive disengagement from SAR activities, which resulted in the choice to reduce the operational area first of Frontex Joint Operation Triton, initiated in 2014, and then Joint Operation Themis, launched in 2018. The operational area of Joint Operation Themis was reduced to cover only the Italian search and rescue region, in contrast to the previous Triton operation, which also extended to the Maltese region. It's important to note here that such a progressive reduction of SAR activities was not limited to Frontex operations, but also impacted on the scope of the Common Security and Defense Policy Operation UNAV-4MED. In March 2019, participating states decided to prolong the mission for a further 6 months, but without deploying naval ships to avoid involvement in SAR operations, focusing instead on air patrols and training of the Libyan Coast Guard. So disengagement from SAR activities, from the provision of SAR services, was accompanied by the progressive delegation of SAR responsibilities to Libyan authorities. Support provided by the EU and the Italian government included funding, training, and provision of equipment, with the aim of increasing the capacity of the Libyan Coast Guard to conduct rescue operation over a newly established Libyan search and rescue region, and setting up a maritime rescue coordination center. The Commission has also considered lawful and compatible with existing fundamental rights obligation, notably the respect of non-refoulement, the sharing of information with Libyan Coast Guard on both sightings provided through satellite maritime surveillance technologies operated by Frontex, such as Eurosur fusion services, and therefore facilitating interceptions by Libyan authorities and return of intercepted boats to Libya. Finally, a last piece of the puzzle concerns what has been referred by some scholars as the crackdown on SAR organizations operating at sea. Especially from 2017 onwards, humanitarian civil society actors involved in SAR activities have been subject to increasing criminalization or policing dynamics. Actions taken to limit SAR NGOs activities have included, among others, legal proceedings on the ground of facilitating irregular entry, the confiscation of vessels, the imposition of administrative fines, and since 2018, port closure and denial of disembarkation into member states' territory. So the range of practices described above raise a set of complex legal issues that are, of course, beyond the scope of my intervention. However, what I would like to point out here is that the assumptions behind those practices seems to be that they can be considered as legitimate migration management strategies. That is, that member states can escape responsibility and legal accountability for their actions or inactions by exploiting gray areas in the existing legal frameworks, including those that lie at the intersection between the law of the sea and human rights norms. I would like now to briefly refer to one specific situation which has been referred to as a disembarkation crisis that unfolded in the central Mediterranean over 2018 and 19. This crisis was triggered by the refusal of the Italian government to accept disembarkation of migrants rescued at sea by NGOs, causing a series of standoffs or delayed disembarkations that forced rescued people to prolonged periods at sea in precarious and unsafe conditions. I think this so-called crisis is interesting because it is an example of how a migration-related crisis can be deliberately manufactured to achieve specific policy objectives and influence EU policy making. At the EU level, cases of forbidden or delayed disembarkations were initially addressed through so-called ad hoc disembarkation and relocation arrangements, involving a small groups of member states accepting to relocate a number of asylum seekers disembarked in Italy and Malta. These arrangements were initially carried out in a purely intergovernmental fashion and without complying with EU asylum rules. And only in early 2019, the Commission and EU agencies, Frontex and EASO, started playing a supporting role in the coordination and implementation of these arrangements. The role of Frontex in that context has mainly related to conducting hotspots-related tasks, such as the identification and fingerprinting of disembarked people. The Malta Declaration, adopted in September 2019, represented an attempt to give a more stable and predictable framework to these arrangements, overcoming the previous ship-by-ship approach. That initiative, however, suffered from a number of shortcomings, which reflected the crisis-led context in which it was formulated. The relocation mechanism envisaged in the declaration has a limited scope, all included people rescued in the central Mediterranean, while relocation commitments were loosely defined without specifying clear rules for distributing applicants among participating states. On the other hand, the declaration includes several paragraphs that reconfirm a set of control measures adopted over the previous years. This includes reference to enhanced EU-led aerial surveillance in the Mediterranean to detect migrant boats, in line with previously mentioned practices conducted by Frontex, including the sharing of information on sightings of vessels with the Libyan Coast Guard. So very synthetically, this is the context in which the new pact on migration was formulated. In line with the language and the narrative of the pact, the Commission proposes a common European approach to search and rescue. The pact recognizes that rescue is an obligation under international law, and I quote, that SAR is a key element of the EU integrated border management system to be implemented as a shared responsibility by Frontex and national authorities, making the boosting of Frontex access to naval and aerial capacity essential. Among the key elements of this common approach to SAR, there is one that deals specifically with Frontex, and specifically, I quote again, Frontex should provide increased operational and technical support within EU competence and deploy maritime assets to member states to improve their capabilities and thus contribute to saving lives at sea. In this way, however, the pact does not include any new element to address the long-standing ambiguity concerning the specific role and mandate of Frontex in the field of search and rescue. On the one hand, SAR activities carried out in the context of Frontex operation at sea are covered by a specific regulation, the 2014-16 Maritime Security Regulation, which provides more precise rules on some key aspects. For example, it provides a protection-driven definition of place of safety for disembarkation, which should take into account protection of fundamental rights and the principle of non-refoulement. Article 4 of the regulation also includes a set of procedural safeguards which apply to all cases of disembarkation in third countries, which aims to ensure the protection of fundamental rights of asylum seekers intercepted or rescued at sea. However, over the previous years, these rules and their application on the ground have not prevented the emergence of multiple allegations of fundamental right violations in the context of Frontex activities, such as failures to respond to distress calls and contributing directly or indirectly to pushbacks and pullbacks episodes. The report, I would like to quote here briefly, the report issued by the European Parliament Frontex Scrutiny Working Group, which was published in last July. The report, while not finding conclusive evidence of the direct involvement of Frontex in pushbacks, nevertheless concludes that the agency was aware of fundamental rights violations in member states with which it had a joint operation, but failed to address and follow up on this violation promptly and effectively. The scrutiny group, the scrutiny working group, pays particular attention to the application of Article 46 of the Frontex regulation, which stipulates that the executive director has a duty to withdraw financing, suspend or terminate activities in case of fundamental rights violations that are serious or likely to persist. In its recommendation, the scrutiny group concluded that clearer criteria and procedures need to be established for the adequate application of Article 46, which must apply to all the activities carried out by Frontex, including aerial support and support in third countries. My last point concerns the link between search and rescue, disembarkation, and solidarity among member states, which has been very much at the core of EU debates over the previous years. So under the new pact on migration and asylum, solidarity measures are included in a specific piece of legislation, the Regulation on Asylum and Migration Management, or RAM, which foresees a specific solidarity mechanism for search and rescue, which applies to cases that generate recurring arrivals in the member states, and according to the Commission, is expected to replace the ad hoc solidarity arrangements of the past years, such as those implemented in the context of the Malta Declaration. The approach to solidarity that has been is laid down in the pact has been widely discussed by scholars, by stakeholders, including the European Parliament Research Service. So I'm not going to enter into the details of this solidarity mechanism. I would like just to limit myself to say that a number of issues have been raised concerning this approach to solidarity, which is included, which is proposed by the Commission in the pact, including its concrete functioning on the ground, so its operationalization, but also more broadly, its coherence and compatibility with the key aims of the common European asylum system, and in particular with the principle of solidarity and fair sharing of responsibility included in the treaties. A first issue is the complex nature of the system, which includes several different stages and combined voluntary pledges with mandatory contributions that need to be determined in line with the distribution key calculated on the basis of member states' GDP and population, and which includes a corrective, a mass correction mechanism to be activated when the Commission finds that pledges under a specific form of solidarity, such as relocation, fall short of identified needs. So the complexity of this system has indeed been identified by not only by observers, but also of member states representatives, which have reacted to the Commission proposal, pointing out a set of concerns regarding the operationalization of this mechanism. The flexible solidarity approach that is laid down in the pact also means that member states may be relieved from mandatory relocation by exchanging their responsibility vis-à-vis refugees with options beyond the asylum sphere, such as expulsions and cooperation with their countries. So in this regard, it is questionable if that margin of discretion left to member states can be seen as contributing to the achievement of a common policy on asylum, posing the risk of further differentiation in this area. Finally, it's also questionable if the proposed solidarity mechanism would be sufficient to compensate for the structural imbalances in the allocation of responsibility produced by the Dublin system, which remains largely in place, as it has also been underlined in the previous panel, and specifically the additional responsibilities that the pact places on member states of first entry in the context of the so-called pre-entry phase. This is also the case because the RAM proposals foresee a set of criteria that exclude some applicants from a relocation, such as the case of applicants falling within the scope of the border procedure, and also applicants which are recognized as posing a specific security risk. So to conclude my intervention, the pact leaves, in my opinion, two main points I would like to make. The pact leaves unaddressed the tension, the long-standing tension between Frontex responsibility to respect and uphold fundamental rights, including saving lives at sea, and its expanding operational mandate in the implementation of migration management and external border control activities, which focus on the prevention of irregular migration. This is particularly the case when the agency is deployed in national context where containment and prevention of entry are pursued without adequate consideration of fundamental right impacts. Second, the last point that I want to make concerns the link between disembarkation following SAR and solidarity, which has been at the core of the EU policy debate. In my opinion, it has also been from time to time instrumentally used for escaping responsibility. But what these disagreements over relocation of people, over solidarity, as implied, is that this circumstance has indeed made politically unfeasible for the agency, Frontex, to play a more proactive role in the field of search and rescue, as called for example, by the European Parliament. In terms of the agency's legal mandate, it would be possible to deploy a Frontex coordinated operation with a specific focus on search and rescue, but this possibility has so far been ruled out by the lack of willingness by interested member states. So I would like to leave it here, and I look forward to the discussion. Thanks.
Thank you very much. Thank you very much indeed, Roberto, for your very interesting presentation. You managed in 15 minutes to give us an idea of the background of this so-called disembarkation crisis. That was very helpful. And also you provided some interesting insights in the new pact and how the new pact addresses or doesn't address this issue. Thank you very much. I'm sure there will be comments and questions during the debate. And now from Warsaw, from the headquarters of Frontex, we fly to Vienna, Austria, and to the Fundamental Rights Agency of the EU, where indeed we have the pleasure of listening to TAMÁS MOLNÁR, who is indeed working there at the Fundamental Rights Agency of the EU as a legal research officer in the research and data unit, focusing on indeed issues such as inter alia fundamental rights of irregular migrants, return, readmission, detention, anti-smuggling. Before joining the agency, Tamás worked in various ministries in Hungary in the fields of international and EU migration law and their domestic implementation. He has been adjunct professor of international law and EU migration law at the Corvinus University of Budapest in the Institute of International Studies. The title of his presentation is EU Fundamental Rights Agency's Role in Monitoring Compliance with Fundamental Rights at the EU External Borders. So Tamás, we are all very curious about hearing your presentation, and the floor is yours. Thank you.
Many thanks, Mr. Chair, dear Francesco, for this kind introduction and for giving me the floor. Ladies and gentlemen, dear participants, first off, a big thanks goes to the organizers for this kind invitation. It's my great pleasure to contribute to this highly topical event and share my thoughts from the perspective of the Fundamental Rights Agency, which is not a law enforcement agency, and it's in principle not an operational agency either, but perhaps we might have and will have some role in monitoring compliance with fundamental rights at the external borders. To accompany my intervention, I am now sharing a few slides with you. I hope you can see it now. I'm putting them on full screen. All fine? Can you see it, the landing page?
Yes.
Okay.
Yes.
Okay. I
Yes,
haven't seen
can.
you nodding. Maybe
Thank
that
you.
was some hiccup with the connection. But all right. So indeed, this is the title. And first, I would like to start with the current situation, meaning what kind of activities FRA has been doing regarding external borders. Lately, we have intensified our work relating to fundamental rights at external borders, which resulted in a number of outcomes and outputs. For instance, a land border report, meaning the fundamental rights at land borders of the EU, which compiles the evidence from various stakeholders and maps the main challenges on the ground. Also reproduced some do's and don'ts, sort of a practical guidance on border controls and fundamental rights at external land borders. And these do's and don'ts are aimed at helping the work of border guards on the ground. So for shift leaders to know what are the basics in this regard. Also in cooperation with the Council of Europe, we equally produced sort of a restatements of the law when it comes to the fundamental rights of refugees, asylum seekers, and migrants at European borders. And more recently, we felt timely to produce a similar compilation on European standards relating to legal remedies, complaint mechanisms, and effective investigations at the borders, as these standards stem from both Council of Europe law, mainly the European Court of Human Rights case law, and European Union law. Similarly, we issued a guidance on initial reception facilities at external borders. It contains 10 points on how to make sure that the setup and the operation of such facilities are fully in compliance with applicable fundamental rights safeguards. And as a, let's say, repeated exercise, we are regularly collecting information also on the situation at on the fundamental rights situation at external borders in our migration quarterly bulletins, which are published every 3 months. Next to this research-related angle, the agency is also getting more and more operational to some extent. For instance, since the beginning of 2018, we have a field presence in Greece. A colleague of ours is based in Athens, and she goes island hopping from one hotspot to another and assesses the situation on the ground and creates and makes reports to us and also to the Commission. Then FRA has also been participating in Schengen evaluation on-site missions as an observer in the on-site teams, also including the area of external borders. For instance, this year, I myself attended such evaluation missions to Greece, Italy, and Malta, and these are very, very insightful to see how member states implement the EU border acquis on the ground, and which are the challenges also from the human rights, fundamental rights perspective. And all these are coupled by ad hoc visits when we get some invitation from member states. For instance, we went, it was already 4 years ago, to the Hungarian transit zones, and we have also been to Spain, and most recently in Lithuania at the border with Belarus. Then let's turn to the future. And when it comes to future plans regarding monitoring at external borders, of course, the point of departure is the a screening proposal and its envisaged independent national monitoring mechanism to be set up by member states. So this is the core obligation, or it is foreseen as an obligation for member states to ensure compliance with international law and EU law, including the EU Charter, during the screening process, and also to ensure compliance with national rules on detention, especially the grounds of detention and its duration, as well as the prohibition of refoulement, and also to make sure that alleged rights violations in relation to screening are dealt with effectively and without delay. Plus, the proposal would also oblige member states to set up investigation schemes into the allegations of no respect of fundamental rights, again, in relation to screening. And I highlighted at this point that this monitoring mechanism or such national mechanisms are meant to operate and cover only the screening process as such. What is the role foreseen from FRA therein? FRA should issue general guidance for member states on the setting up of such mechanism and its independence. In addition to that, member states may request FRA, if they wish so, to support them in the development of such mechanisms, including the safeguards for independence, then the monitoring methodology, as well as the appropriate training schemes. And another may clause also envisages that member states are entitled to invite other, let's say, national, international bodies or NGOs to participate in the monitoring scheme. So this is the proposal in a nutshell with regards to monitoring. And now just a quick assessment of the relevant provision in the proposal and how we see it. Overall, the agency, our agency, FRA, welcomes the proposal, and we are supportive of the monitoring to be carried out by national actors, which allows adjustments to the realities on the ground, and it also makes sure that the specificities of the situation in a given member state can be best addressed, also to build on the work of national human rights institutions or national preventive mechanisms, which are in a number of cases already involved in such monitoring exercise. It's also positive that there's a clear statement on independence of such bodies. It has a number of advantages. Establishing independent mechanisms at borders has proven to be a useful way for states to ensure that border control activities comply with fundamental rights. And such a monitoring mechanism can also help identify problems, gaps, and training needs, and could increase transparency on the fundamental rights situation at the border. Not mentioning that it can help address deficiencies and also facilitate investigations. Another thing that we are supportive of is the duty to investigate allegations of fundamental rights violations. Having said that, still there are some concerns or room for improvement. First is the material scope. Since the main issues at borders, the main fundamental rights issues at borders are pushbacks, and hence the highest need for monitoring comes up in the context of border surveillance activities, and not just in relation to the screening. And border surveillance is not covered by the text. You can see my rudimentary and now primitive drawing, which shows the overlap between the screening and all other border surveillance related activities, and the overlap is quite thin. The main issues are not happening in the stricto sensu screening context. Hence, a suggestion would be to open up this monitoring mechanism to border surveillance, for instance, by amending the Schengen Borders Code in this regard. The second thing is detention. And not just the detention grounds and conditions should be monitored, or detention grounds and the detention grounds should be monitored, but the procedural safeguards and the conditions in detention should be also mentioned explicitly to go the full circle. And right now, there's only a reference to national law, that detention should be in line with national law, but it's not enough. Member states have a number of international obligations to comply with, which should also be reflected. Third, independence safeguards should be explicitly spelled out in the regulation itself, just to have more robust provisions in this regard. Then we also think that a non-affectation clause would be beneficial to clarify that this new mechanism doesn't affect the mandates of existing monitoring bodies. And finally, investigations, the language should be beefed up. And investigations must be prompt, expeditious, and capable of leading to the identification and punishment of those responsible, as required by the case law of the European Court of Human Rights. The current language, to be effective and without delay, falls short of this, and a more stringent language is needed than currently in the proposal. And this is my last slide to focus a bit on FRA's role. I mean, Of course, our agency stands ready to contribute with its expertise in line with the provisions which will be set out in EU law. It's still a moving target, but it's important to underscore right now that the proposed rules will not give FRA a monitoring mandate. It's not FRA to carry out. I mean, FRA is to undertake capacity building work to help member states set up their own systems. And I mean, we just don't have the capacity to do monitoring on the ground. I mean, we are an agency with a bit more than 110 people. The asylum and migration team, where I belong to, is only composed of some 10 people. So 10 people for a union of 450 million people with 27 member states, of course, it's just a no-go. So we are just there as a center of excellence to give advice. And a couple of substantive points. We believe that to be effective, national mechanisms should include safeguards for unimpeded access to places, people, documents, and it should be able to monitor all relevant activities. And to do so, sufficient resources need to be allocated. And such mechanisms have to be complementary to and build on other law-based mechanisms, such as the NPMs under the optional protocol to the Convention Against Torture. And now, during the negotiations, which are still ongoing, and it's been a long way, technical details regarding the relationship between FRA and the national monitoring mechanisms need to be defined as well. As for the state of play, you might be aware that the draft LIBE report has recently been published. It even wants to raise the standards and wants to expand monitoring into super monitoring, not just covering screening, but also border surveillance, rightly so, but also asylum and return procedures. And it aims at beefing up the Commission proposes a number of other points, like monitoring to trigger investigations. And then I must say that a number of points I just mentioned have been integrated into the LIBE draft report. We have been in touch, of course, with them, and we contribute to a number of hearings and shadow rapporteurs meetings with our expertise. But this contrasts to the very little appetite in the Council at working party level. As far as I know, only 2 or 3 member states are supportive of setting out such a monitoring mechanism. So there's quite a big gap to bridge somehow. And once approved, FRA will engage with relevant international bodies, especially the Council of Europe. Think of the CPT, for instance, as well as the subcommittee subcommittee on the prevention of torture, which is a UN body, and also a European NPMs to conceptualize the mechanism. And also, when it's rolled out in the best case scenario, such mechanisms will start functioning in the foreseeable future. During their establishment as well, we will liaise with these international stakeholders when developing the guidance, methodologies, and designing the training. So I would leave it here. Thanks for your kind attention, and I'm at your disposal for further questions and comments. Thank you again.
Thank you very much. Thank you very much indeed, Tamás, for your very interesting and thought-provoking presentation. Also, excellent time management. Thank you very much. So we have now about 25 minutes, more or less, for a debate. So I will indeed open the floor for questions, comments, remarks. You can, as you know, you can either use the raise your hand function or write something in the chat. So I see, okay, thank you very much. I see Mario and Daniela. I will, okay, then collect a couple of questions. So let's indeed begin with Mario, maybe. The floor is yours.
No, ladies first, and Daniela was quicker.
Okay. She clicked the button quicker than you. All right then. Okay, Daniela, please.
Thank you. Thanks, Francesco. Let me thank both our presenters for their uplifting discussion of crucial issues concerning the management of maritime borders and the need to adjust monitoring strategies. I would like to pose one question to each of them. So for Roberto, I recently ran into the implementing regulation 581. adopted by the Commission to revamp Eurosur cooperation and enforced since last May. And to my understanding, this regulation foresees, among other measures, new obligations for Frontex to notify each and every event observed during search and rescue activities carried out within the scope of Regulation 656. And in particular, information on any abnormal trend or a new modus operandi developing at the external borders. I was wondering, what do you think of this development and whether you think it could help streamline Frontex power and responsibility in search and rescue activities? My questions to Tamás is much more a curiosity than a question. Actually, I was wondering whether you reasoned around, you know, the role that FRA could play within, of course, the supervisory role that FRA could play within the framework of joint enforcement activity. I mean, you very well explained that at present there is no room, I mean, for an active role, at least as far as you know, strong monitoring is concerned. But in prospect, I was wondering, I mean, what do you think could be done to strengthen this role? Thank you very much.
Thank you, Daniela. Maybe Mario, we can collect also your thoughts here. Yeah.
Many thanks, Francesco, and above all, many thanks to our speakers, both of them very brilliant in their presentations, and they raised a lot of big issues. I will try to address a couple of questions to Roberto, and then another couple to Tamás. To Roberto, this is just a factual question. Is Frontex directly involved in the training of the Libyan Coast Guard or not? And my second question is, I assume that Frontex doesn't have a duty to report in case its units become aware of fundamental rights violations committed by member states in the management of the border, such as pushbacks. But then we know that Frontex withdraw from supporting some member states because of the gross violations committed at borders. So my second question would be here: what are the criteria according to which Frontex decides whether to withdraw or not? To Tamás, well, my general comment would be, following your presentation, would be a fundamental rights agency, at least as far as the monitoring of external borders is concerned, sounds like a promise that cannot be kept. Now, I mean, my question has been already basically addressed by your very detailed presentation. I wonder whether there are means to strengthen the independence of monitoring mechanisms at national level, and by, for instance, establishing, I repeat again, more or less the same question that I put to Lilian with regard to EASO. Can we foresee a future in which the Fundamental Rights Agency becomes the head of a sort of pyramid of monitoring bodies at European Union level? And can we foresee a future in which this agency is entrusted with direct monitoring tasks with regard to Frontex, for instance? Thank you.
Thank you very much, Mario, for these questions and comments, also remarks. Okay, so I would proceed in the reverse order, if that is okay. So I will first give Tamás the opportunity to reply. Tamás, the floor is yours. yours.
Thanks, Francesco. Thanks, dear colleagues, for the very intriguing questions. I start with Daniela's one. So FRA's role in future to be strengthened and to, let's say, do monitoring on its own. I don't see it happening as of now, given that even the current version of the monitoring mechanism is very hard to how to say to be digested by member states, and it's not FRA's role which is most at stake, but just the fact that the European Union wishes to foresee common European rules on how each and every member state should set up a monitoring mechanism in their domestic law and within their national, institutional framework. It's already a bit too much as of now. And departing from realpolitik, which was not only a useful, how to say, descripting narrative during Bismarck's time, but also these days in Europe, I think we are just far from there. Maybe in 50 years, perhaps, but it's really a bit legal science fiction to say that once FRA will get this role. So I think we are not there yet, and not in the near future. And turning to Mario's question, how to strengthen the independence of the monitoring mechanism and FRA as on the top of this so-called pyramids of monitoring structures, which is to some extent, it speaks to Daniela's question, that if FRA had this role, I think that wouldn't be enough just to give this function in a piece of secondary EU legislation, like in the screening proposal, but it would also require a major overhaul of our mandate, since FRA's mandate is something different. We are like, as our director likes to say, the center of excellence in the EU to provide fundamental rights advice. We are like a supranational think tank. We are not a fully fledged monitoring body. We are doing research, comparative reports. We just give advice and technical assistance to EU institutions and member states so that they can implement EU law and also make EU law in a fundamental rights proof manner. So, I mean, that would be a paradigm shift in terms of FRA's role. And I think not mentioning just the political, how to say, difficulties of that, it would also require the amendment of FRA's funding regulation, which is based on the flexibility clause, Article 352, which requires unanimity from the member states. And I don't think that unanimity could be reached on that very sensitive manner. And your second question is monitoring Frontex by FRA. I think it's not for us, since Frontex has its own monitoring structure in place, notably the fundamental rights monitors, who are meant to be the ears and the eyes of Frontex in all operations on the ground, to monitor, to follow what's happening and how Frontex staff are carrying out their obligations. So I think it's already established, and involving FRA in that would be a sort of a conflicting situation. Nevertheless, one thing that I would mention here, that we have established a pilot project with Frontex, with the fundamental rights officer of Frontex, to help them setting up this fundamental rights monitoring role. We produced a manual on the methodology of fundamental rights monitoring. We went to some pilot missions with representatives of the Fundamental Rights Office to show on the ground where to look, what to look, how to assess the compliance with fundamental rights in real actions. And yeah, I mean, this project has ended, and the deliverables have been handed over to the Fundamental Rights Office. But that was our role, this supporting role in the initial phase of the training or developing of the fundamental rights monitoring scheme within the Frontex agency. And yeah, I would leave it here, or maybe just to steal or to reflect on one other question which was not addressed to me, but it's interesting whether if Frontex staff witness something on the ground which is against fundamental rights, or some violation committed by national border guards, so those deployed by member states, there's an avenue called serious incident reports, the SIR, as we call it in abbreviated form, that can be used. So if even Frontex staff see something which is unacceptable or can raise fundamental rights concerns, this avenue, this serious incident reports can be triggered, which then have to be investigated in Frontex. Thank you.
Thank you very much, Tamás, for this picture, also of this realistic picture of the difficulties also that the agency has in terms also of capacities, resources. And personally, I find quite interesting, but also telling the fact that the agency is cooperating with the Council of Europe. So maybe rather than from Brussels, from Strasbourg, maybe a little bit of support or enthusiasm can come when it comes to fundamental rights. Okay, now it's the turn of Roberto to express his point of view and remarks and to reply the questions. Roberto, please.
Many thanks, Francesco. I would like first to address to the question by Daniela. Thanks for pointing to that regulation, implementing regulation of Eurosur. I had to admit I was not aware of this specific regulation. It's very interesting to see if this regulation could improve the accountability and also the kind of scrutiny over the activities of Eurosur. It seems to me, from having a first look at it, more related to the internal quality control mechanisms. So I will not be able to say now to which extent, to reply to your question, this regulation would improve on the accountability of Eurosur. What is striking concerning Eurosur is that the system has developed substantially over the last few years, and however, at least in official discourse by Frontex, the possible fundamental right dimension of this of the activities conducted through Eurosur, including cooperation with and sharing of information with maritime rescue coordination centers in third countries, such as the Libyan one, to my knowledge, I've never been acknowledged as an issue posing fundamental posing issues in terms of fundamental rights obligations and compliance with Frontex positive obligations also to avoid fundamental rights violations, and also the obligations that are and the rules that are included in the maritime Frontex regulations, which to some extent we can discuss a bit on the scope of the activities and the scope of circumstances included in the regulation, but it basically includes fundamental rights. It includes provisions that aims at protecting fundamental rights when migrants rescued that are handed over or conducted to third countries. So that's I think it's a very interesting to see future developments in this in the field of Eurosur, which is not so much often on let's say on the spotlight. Coming to Mario's very interesting questions, the first question concerning the Frontex role in training the Libyan Coast Guard, if Frontex has played a specific role in training the Libyan Coast Guard. To my knowledge, yes. I'm not sure I'm updated with recent developments about this, but to my previous knowledge in the context of previous research, I remember that Frontex was also involved in training of the Libyan Coast Guard. Frontex also collaborated with training activities, if I remember correctly, carried out under the framework of the UNAVA FORMED operations, which had a focus on training. And in that context, Frontex also was involved in providing training on a number of aspects related to activities conducted at sea. Finally, concerning the question of Frontex reporting duties, TAMÁS was mentioning, and it's I think it's very relevant, the internal mechanism that Frontex is as in place to report serious incidents. I found very interesting in this regard the report that was issued by the European Parliament working group on Frontex, which has focused on a number of aspects and shortcomings specifically related to the internal procedures that are in place to make sure that those incidents and are properly investigated, there are properly there are clear and reliable follow-up procedures to address these reports of incidents. And what emerges from this report of the Parliament is that there has not always been a proactive approach by Frontex Management Board, by the Executive Director in addressing these reports. And finally, there is also a focus on the report on Article 46, which includes an obligation by Frontex to suspend or terminate operations when it identifies fundamental rights violations. And also in this case, however, what is underlined is that the specific procedures for implementing, let's say, this article has not always been clarified and specified by the agency, including through internal procedures. So both the Parliament report, but also a previous report by the Frontex Management Board called for strengthening these procedures and for making them more effective and more timely, so not to wait, as in was the case with Hungary, that a judgment for the Court of Justice is there in order for Frontex to suspend its operation in Hungary. So it remains to be seen if these suggestions, recommendations by the Parliament report and also internal actions taken by Frontex would improve the situation in the future, increasing the accountability and also the responsiveness of the agency to cases of fundamental rights violation, and will change the course, the approach of the agency when engaging with member states in which evidence on the ground points to aspects of concerns when it comes to fundamental rights, respect of fundamental rights.
Okay, thank you very much. Thank you very much, Roberto, for your thoughts and your answers. We have a couple of minutes left. There are many interesting issues, including Article 46, indeed, of the recent Frontex regulation, whether there is indeed this duty to withdraw support. Also, this SIR mechanism, serious incident report mechanism, we have additional information in the chat put there by TAMÁS. Thank you very much. I wonder actually whether this mechanism has ever been activated. And so where and what does it mean serious incident also?
If I may, yes, I mean, the SIR reports have been already like an existing tool, and it's not just on paper, but these have been activated. I can't go into the details because of confidentiality, but just to give you a couple of locations where from where these reports have been received. Greek land borders from the Evros region, but also now in Lithuania because of the situation at the border with Belarus, and so there are indeed SIR reports. Not all of them concern fundamental rights issues, but of course a number of them are related to alleged violations or non-compliance with fundamental rights standards. And if they concern fundamental rights issues, then this is the Fundamental Rights Office which will handle and which will look into those reports.
Okay, great. Thank you very much for the clarifications. So there is indeed something going on at the Belarus border. Okay, so we are 1 minute ahead the schedule, but I think we had really a very intense and fruitful afternoon. It was a pleasure being with us, being with you. I mean, thank you very much to all the speakers. Thank you very much for everyone in the audience. And what else? I guess we see next year for the 5th annual conference of the Academy of Law and Migration. But of course, the Academy of Law and Migration has much else in his pocket for the next time. So thank you very much for your participation, and see you soon. See you very soon.
Thanks again. Well done. It was my pleasure, and all the best. Keep up the good work. Bye-bye.
Thank you, and bye-bye.
Thank you. Bye-bye. Thanks a lot.
Bye.
Bye.